The House will come to order. Members and visitors in the gallery, please rise for the prayer. We are pleased to have with us today Reverend Charleston Wilson with Church of the Redeemer in Sarasota at the invitation of Representative McFarland. Reverend Wilson, please approach the well.
Let us pray. Almighty God, unto whom all hearts are open, all desires known, and from whom no secrets are hid, we gather today beneath the bright canopy and bright future of this sunshine state. Lift up our hearts. We thank you for the great state of Florida. Bless, O Lord, those gathered here to serve the public. The Holy Scriptures tell us in Psalm 107 that some went out on the sea in ships. They saw the works of the Lord, his wonderful deeds in the deep. So like those ancient mariners, may the lawmakers in this chamber navigate the complexities of our time with steady hands. When the storms of partisanship rise, be their anchor. When the fog of uncertainty rolls in, be their lighthouse. We ask for the grace of St. Francis, that these leaders be instruments of peace. Where there is discord, let them sow union. Where there is doubt, faith. And where there is shadow, the light of clear purpose. We ask for the spirit of St. Jude, the patron of difficult causes, to guide these men and women working on our state's most complex challenges. May they and we always remember the promises in St. Matthew. With man, this is impossible, but with God, all things are possible. Bless our state's entrepreneurial pioneers, every worker, the retirees, and the children of Florida. Let the legislation passed here reflect the warmth of our climate, and may it warm up today, as well as the resilience of our spirit. May those who take counsel here work together so that every Floridian, from the busiest city to the quietest inland town, may live a life of dignity, peace, and prosperity. Finally, bless, O Lord, also the families of these public servants, the staff and volunteers who labor here behind the scenes, and every Floridian watching today. Keep us humble, Lord, in the time of abundance. Make us quick to give you praise, and in the times of trial, suffer not our trust in thee to fail. In your holy name we pray. Amen.
Thank you, Reverend. The clerk will unlock the machine and the members will record their presence. Have all members recorded their presence? The clerk will lock the machine and announce the presence of a quorum.
108 members voting. A quorum is present, Mr. Speaker.
Members and visitors in the gallery, please rise for the Pledge of Allegiance to the flag. The Pledge of Allegiance will be led by Jeffrey Ballard from Tallahassee at the invitation of Representative Duggan, Agustin Buñuel from Miami Springs at the invitation of Representative Rizzo, Caroline Cusson from West Melbourne at the invitation of Representative Miller, George Fowler from Santa Rosa Beach at the invitation of Representative Abbott, Selena Lim from Apopka at the invitation of Representative Bankson, Matthew Loomis from Sarasota at the invitation of Representative McFarland, Logan Newell from Winter Garden at the invitation of Representative Baker, Matthew Scarry from Punta Gorda at the invitation of Representative Nix, Parker Whitehead from Lake Ellen at the invitation of Representative Barnaby, Mila Zavala from Weston at the invitation of Representative Bartleman. We are honored today to be joined by our law enforcement officer of the day, Chief Jesse Godfrey, with the Ormond Beach Police Department at the invitation of Representative Partington. Chief Godfrey, thank you for your service and welcome to the Florida House. Are there corrections to the journal? Hearing none, show the journal approved. Are there reports of standing committees and subcommittees?
On the desk, Mr. Speaker.
Read the report.
The Honorable Daniel Perez, Speaker. Dear Mr. Speaker, your Rules and Ethics Committee herewith submits the special order for Thursday, January 15th, 2026. Consideration of the House bills on special orders shall include the Senate companion measures on the House calendar. Reading of the report, Mr. Speaker.
Representative Garrison, you are recognized on the report.
Thank you, Mr. Speaker. The report sets a special order calendar and allocation of times for questions and debate, and I move adoption of the special order report for today, Jan 15, 2026.
Are there questions? Is there debate? All in favor say yea. Yay. Opposed, no. Show the special order report adopted. Are there other reports?
None on the desk, Mr. Speaker.
Are there motions relating to committee and subcommittee references? Are there matters on reconsideration? Are there bills or joint resolutions on third reading?
None on the desk, Mr. Speaker.
Are there bills on the special order calendar?
On the desk, Mr. Speaker.
Read the first bill.
By Representative McClure and Representative Gentry, House Bill 167, a bill to be entitled, an act relating to former phosphate mining lands.
Members, before we get started, please join me in welcoming back former Speaker Pro Tem Chuck Clemens to the Florida House. Representative McClure, you're recognized to explain your bill.
Thank you, Mr. Speaker. This is a very simple bill that allows for the removal of strict liability on previously mined phosphate lands if two conditions are met. The first being a Department of Health study is conducted at the request of the owner, and secondly, it is recorded with the municipality that it is a formerly mined phosphate land, and that is the bill.
Questions of the sponsor? Representative Cross, you're recognized.
Thank you, Mr. Speaker. Representative McClure, in this bill, can you explain how a future landowner would be notified that the piece of property that they're buying or renting is former phosphate lands?
Representative McClure.
Thank you, Mr. Speaker. Well, obviously, Florida is a buyer beware state, so it is incumbent upon the purchaser in normal real estate transactions to do their due diligence. But above and beyond that, as I explained in the opening and in previous committee stops, there will be a public record that it was formerly mined, and the Department of Health study, the data from that will be publicly available.
Representative Cross.
Thank you, Mr. Speaker. So in a real estate transaction, it may be reasonable for someone working with a registered real estate professional to know of this kind of like a lien on a home or a property. How would a renter know about this?
Representative McClure.
Thank you, Mr. Speaker. The same way that a renter would find out information about a former gas station or laundromat or any other previous land use.
Further questions? Are there further questions? Seeing none, are there amendments?
None on the desk, Mr. Speaker.
Show the bill rolled over for third reading. Representative McClure, you're recognized for a motion.
Mr. Speaker, I move the rules be waived and House Bill 167 be read a third time by title and placed on final passage.
Representative McClure moves that the rules be waived and that House Bill 167 be read a third time by title and placed on final passage. All in favor say yay. Yay. Opposed, no. Show the motion adopted. Read the bill a third time by title.
By Representative McClure and Representative Gentry, House Bill 167, a bill to be entitled, an act relating to former phosphate mining lands.
Are there any amendments?
None on the desk, Mr. Speaker.
Members, we're going into structured debate on HB 167. Debate will be limited to 10 minutes per side in 10-minute increments. Total debate time not to exceed 20 minutes. Representative Gant, you are recognized in debate.
Thank you, Mr. Speaker. I yield the floor to Representative Cross.
Representative Cross.
Thank you, Mr. Speaker. Members, we all know that choosing where to live, what neighborhood to select, which house to purchase, or which apartment to rent is one of the most important decisions that we can make. It affects our finance, it affects our health, and it affects our quality of life. From hearing this bill in committee and in conversations with the bill sponsor, I've considered some of our existing rules and regulations regarding notifying future buyers of land once developed who are actually planning to live there. It's important that future homeowners or tenants, those who will be making these incredibly important decisions, be preemptively notified and well-informed about any risk associated with environmental hazards. The bill as written does not provide additional notification for future landowners, or particularly those in the renting community. Just as we have disclosures for lead paint and now for flooding, I believe that we should preemptively educate prospective buyers and tenants about where they will be living, going above and beyond having this recorded in a county record. Frankly, moving from a buyer beware stance on former phosphate mining lands may be problematic and lead to unintended harm for future residents. In the same legislative session where we're voting on this bill, this body is considering reducing local wetland buffers to accommodate buyers who wish to develop on buffer zones. The same buyers who didn't do their due diligence on important local environmental regulations when buying land to develop, and then may be frustrated that they can't utilize every square footage for new property development. Shouldn't we be holding every buyer, every developer, and every future homeowner to the same standard? Shouldn't we inform them of any apparent risk to their health and property to the best of their ability? I believe that this bill will have the unintended consequence of putting future families at risk, particularly those in our renting community. And for those reasons, I can't vote on the bill, and I urge you to vote no as well. Thank you.
Representative Gant.
Thank you, Mr. Speaker. I yield the floor to Representative Nixon.
Representative Nixon.
Thank you, Mr. Speaker. As someone who was born and raised on a brownfields dump site, I know firsthand what it's like to grow up and live on contaminated soil. My brother having suffered from cancer when he was born, in addition to being born with a major abnormality, being one kidney. And so I would ask, excuse me, I would ask and urge my colleagues to vote down on this bill. As Representative Cross so eloquently put, it is really important for us to do things to preemptively disclose these types of issues. As many of you all know, we are facing a affordability crisis. And right now, people are just excited to be able to move into a home or into an apartment that they can, and they won't do their due diligence to actually do the research. They just want to get off the streets and be housed. And so as legislators, it's really important for us to look out for the safety and well-being of all Floridians here, and this bill does the opposite of that. And so I am strongly urging my colleagues to vote down on this. If you care about the safety of your constituents, you will vote no. Thank you.
Representative Gant.
Thank you, Mr. Speaker. I yield the floor to Representative Escamani.
Representative Dr. Escamani.
Wow, thank you so much, Mr. Speaker. I appreciate that. And I'll be very brief. I want to echo the comments that were already made, but also add another layer to this. Many folks might have missed this update, but there was reporting earlier this week from the EPA that they're no longer going to be looking at the cost of human life in basically determining environmental concerns. And instead, they're going to focus on the cost of doing business. What's the cost to a corporation to have environmental regulations? And so for me, when we look at policy, we have to think about the bigger picture, what's happening at the federal level, the state level, and the local level. And I really would have liked to see, as Rep. Cross spoke to, more transparency, because I understand the chair's point about Florida being a buyer beware state, but I don't want us to be a buyer beware state. I don't think that's a good status quo to maintain, and I would rather see us reform that approach to ensure that the buyer has more information, especially if you're a renter who's going to be moving into a location several degrees separate from this initial transaction. And so for those reasons and more, I encourage members to vote down this bill. Thank you, Mr. Speaker.
Representative Gant.
Thank you, Mr. Speaker. We yield the remaining balance of our time. We yield back the remaining balance of our time.
Thank you. Representative Maggard.
Thank you, Mr. Speaker. We yield back our time in total.
Thank you. Representative McClure, you're recognized to close.
Thank you, Mr. Speaker. I'll be brief, it being the first bill of session. I do want to point out or clarify, unlike lead-based paint or some of these other disclosures, the mere fact that once upon a time a piece of machinery excavated a hole doesn't inherently mean, unlike with lead-based paint, of course, that it's a contaminant or a carcinogen. We are not adjusting any environmental regulations or processes. the federal and state processes on contamination still are applicable. So I feel very comfortable with that side of it. I also think this is a bill that we've talked about for 3 or 4 years in this chamber. There's been a lot of input, and this is good middle ground. Even, you know, the DOH study I've said in committee is something that I probably, without the conversations, wouldn't have included. So very fulfilled that we're getting this bill hopefully off the floor here in just a minute. And then lastly, I would say that, you know, this is a bill that would have passed last year. It's something that the Senate President pointed out as being very important to him, and but for the Rules Chair in the Florida Senate blowing a hole in the side of it for no real reason, I think it would have gotten done. And so we're going to send this bill over early. They're going to have plenty of time to think through it, and hopefully they get it passed. And with that, I close.
Representative McClure, having closed on his bill, the question now recurs on final passage of HB 167. The clerk will unlock the machine and the members will proceed to vote. Have all members voted? Have all members voted? The clerk will lock the machine and announce the vote.
87 yeas, 24 nays, Mr. Speaker.
Show the bill passes. Read the next bill.
By Representative McFarland, House Bill 145, a bill to be entitled An Act Relating to Suits Against the Government.
Representative McFarland, you're recognized to present your bill.
Thank you, Mr. Speaker. House Bill 145 provides an update to our sovereign entity financial liability caps, which were last updated in 2010. It retains the liability shield for government, but modernizes the way that citizens can seek redress when harmed by their own government. The bill proposes to raise the caps on sovereign immunity to $500,000 per person and $1 million per incident, with an automatic increase in 5 years to $600,000 and $1.2 million. It aligns the statute of limitations, so victims have the same amount of time to bring a claim against a government entity as they would against a private one. And it gives government entities the option to settle above the sovereign immunity caps if they elect to, and prevents insurance companies from withholding payment until a claim bill has passed the legislature. And that, members, is the bill.
Question to the sponsor. Are there questions of the sponsor? Are there any amendments?
None on the desk, Mr. Speaker.
Show the bill rolled over for third reading. Representative McFarland, you're recognized for a motion.
Thank you, Mr. Speaker. I move the rules be waived and House Bill 145 be read a third time by title and placed on final passage.
Representative McFarland moves that the rules be waived and HB 145 be read a third time by title and placed on final passage. All in favor say yea. Yea. Opposed, no. Show the motion adopted. Read the bill a third time by title.
By Representative McFarland, House Bill 145, a bill to be entitled An Act Relating to Suits Against the Government.
Are there any amendments?
None on the desk, Mr. Speaker.
Is there any debate? Is there any debate? Representative McFarland, you're recognized to close.
Thank you, Mr. Speaker. Members, the concept of sovereign immunity comes from Old English law, where the king was said to be beyond reproach. Now, as Americans, we have a pretty deep disdain for monarchs, but we also hate taxes, which means we've carried forward a version of this Old English idea, but shaped it to fit our own system. In Florida today, our sovereigns are our local governments. And while they're not shielded from accountability, they're shielded from financial liability above $200,000 today, which serves as a disincentive from people bringing any lawsuit, regardless of merit, against a sovereign entity. When a victim of government negligence has a strong case, our laws restrict them from getting compensation above $200,000 without filing a claims bill and coming up to the legislature and asking for an act of legislative grace. We know this process well. You have to find a bill sponsor. You have to keep your attorney with you. You have to hope that a lobbyist will represent you. And then you also have to hope that both chambers of government will be inclined to hear a claims bill. It's an incredibly arduous and difficult process. You'll remember at the end of last session, in one of the final days, we voted on a slew of claims bills on the floor. And I made the point, even though it was late at night and we were all tired, to debate every single one of them and draw your attention to the fact that these were terrible, terrible cases of negligence. Loss of limb, loss of life, loss of prosperity. And our residents had to come up to us before they could be made whole. Now, this bill doesn't change that. Claims bills will still come before us as a legislature. It just means that more citizens will be able to seek redress against their government. I want you to know that today, if you or I or one of our loved ones were, God forbid, to be hit by a truck, we have to pay attention to whether on the side of that truck there is a corporate logo, no logo, or a government seal. Depending on what that vehicle is and who is driving that vehicle, we have different access to monetary wholeness, and that doesn't sit right with me. I don't think it should sit right with you. I know you've been lobbied by your local governments back home because this will increase in some way the cost of local governments because we're increasing their liability. I know they're gonna have to pay more in insurance. I'm just telling you it's worth it and it's time. I ask for your support of this bill today. Thank you, Mr. Speaker.
The question now recurs on final passage of HB 145. The clerk will unlock the machine and the members will proceed to vote. Have all members voted? Have all members voted? The clerk will lock the machine and announce the vote.
104 yeas, 7 nays, Mr. Speaker.
Show the bill passes. Read the next bill.
By Civil Justice and Claims Subcommittee and Representative Greco and others. CS for House Bill 289, a bill to be entitled An Act Relating to Civil Liability for the Wrongful Death of an Unborn Child.
Representative Greco, you're recognized to explain your bill.
Thank you, Mr. Speaker. HB 289 amends Florida's Wrongful Death Act to include the parents of an unborn child in the definition of survivors. That is the bill, Mr. Speaker.
Questions of the sponsor? Representative Tant.
Thank you, Mr. Speaker. Representative, under Section 755.0215E in our statutes, an unborn child means a person at any stage of development carried in the womb. So I got pregnant between my twins and my daughter with a pregnancy that, with the assistance of a fertility specialist. I had a positive pregnancy test for weeks. I was diagnosed positively pregnant. I went in for a confirming ultrasound where they found that it was a blighted ovum. Under those circumstances, that blighted ovum that was in my womb was never going to be viable. Under your bill, would my doctor or myself be liable for the loss of that pregnancy?
Representative Greco.
Thank you, Mr. Speaker. Thank you, Representative, for the question. So, to first part of your question, would you be liable for that pregnancy? Under the bill, in no circumstance. The bill makes it explicitly clear that the mother of an unborn child can never be the subject of an action under this bill. As far as your physician, the bill also makes it clear that this bill cannot be used against a healthcare provider for lawful medical care provided within the applicable standard of care, meaning that if the medical care was not negligent, your doctor could also not be the subject of a lawsuit under this bill.
Representative Tant.
Thank you. Would anybody else be able to bring a suit under your bill?
Representative Greco.
Thank you, Mr. Speaker. Thank you, Representative, for the question. So in any wrongful death action, a personal representative needs to be appointed to be the representative of the estate and file the lawsuit. There is a process under which an individual can be certified as a personal representative. There's an order of precedence. There's a list of people who are prohibited from being a personal representative. So in this case and in any case, in order for somebody to file a lawsuit under the Wrongful Death Act, whether for an unborn child or anybody else, there's a process to appoint a personal representative, and only that person can file the lawsuit. That is step 1A of any action under the Wrongful Death Act.
Representative Tant.
So would that apply to my husband or my partner who got me pregnant or someone else in my family who was my representative?
Representative Greco.
Thank you, Mr. Speaker. Thank you, Representative, for the question. Your husband could possibly be a personal representative, but again, they would have to go through the process of being appointed by a court as the personal representative. There's an order of precedence, and in the case of an intestate death, which the loss of an unborn child would necessarily be, because the unborn child would not have a will, the order of precedence would determine who can be the personal representative, who cannot be the personal representative, and what a court has to determine in order to certify somebody as the PR.
Representative Gottlieb.
Thank you, Mr. Speaker. Representative Greco, what I want to know is what basis under your bill are you utilizing to determine lost support from fertilized egg, and how is this to be calculated?
Representative Greco.
Thank you, Mr. Speaker. Thank you, Representative, for the question.
The process for determining any damages under this bill would be the same as determining damages in any wrongful death action. The burden of proof would rest with the plaintiff, and ultimately that would be a factual determination for the jury. Right now, today, in Florida, we can have a wrongful death action for the death of an extremely young child, weeks, days, even moments old, who dies as the cause of a wrongful action. And in those cases, today, in Florida, we have lawyers, we have experts, and we have juries who are able to determine what those damages are. Again, that's a fact-sensitive determination for a jury, and at the end of the day, in the state and in our judicial system around the country, we trust juries. But the burden of proof rests with the plaintiff, and ultimately that's a factual determination that a jury would have to make.
Representative Gottlieb.
Thank you, Mr. Speaker. Representative Greco, are there caps on damages in your bill for pain, suffering, emotional distress, and economic damages?
Representative Greco.
Thank you, Mr. Speaker. Thank you for the question. My bill exists entirely within Florida's Wrongful Death Act and exists within the legal institutions of the Wrongful Death Act. The Wrongful Death Act does not have any monetary caps on damages. That said, there are limitations on the types of damages that are available under the Wrongful Death Act, but the Wrongful Death Act for unborn children or anybody else does not include monetary caps on damages.
Representative Rayner.
Thank you so much, Mr. Speaker. Representative Greco, I wanted to know what specific damages does your bill allow that is not currently encapsulated in law?
Representative Greco.
Thank you, Mr. Speaker, and thank you, Representative, for the question. So under current Florida law, an unborn child cannot be the basis of a cause of action under the Wrongful Death Act. Florida Supreme Court has spoken on that and definitively said that. So this bill would change the law to allow for an unborn child, the wrongful death of an unborn child, to be the basis of an action under Florida's Wrongful Death Act.
Representative Rayner.
Thank you so much, Mr. Speaker, and I understand the basis. I think my specific question, what damages does your bill allow that is not currently in law? So specifically as to damages.
Representative Greco.
Thank you, Mr. Speaker, and thank you, Representative, for the question. Again, given that currently in Florida law, an unborn child cannot be the basis for an action under the Wrongful Death Act at all, currently the wrongful death of an unborn child could not result in damages under the Wrongful Death Act, again, because that loss under current Florida law could not even be the basis of an action.
Representative Rayner.
Thank you so much, Mr. Speaker. And at what point in pregnancy does your bill contemplate that a pregnancy or to be considered to be a decedent? I mean, for lack of a better phrasing.
Representative Greco.
Thank you, Mr. Speaker. Thank you, Representative, for the question. So this bill does not write a definition for what an unborn child is. We simply cite to other Florida statute 775.021, which defines what an unborn child is. This is long existing Florida statute. It's not new to this bill. It's just a citation. This is the same definition that you find throughout Florida law when Florida law discusses an unborn child.
Representative Rayner.
Thank you, Mr. Speaker. So with that being said, is the contemplation that your bill would assert an ideology that life begins at conception?
Representative Greco.
Thank you, Mr. Speaker. Thank you for the question, Representative. Again, this bill does not write a definition or include a specific definition for unborn child. It cites to existing Florida statute that is elsewhere in Florida statute that we find throughout Florida statute when we discuss unborn children. That's the definition included in this bill.
Representative Harris.
Thank you, Mr. Speaker. Representative, what safeguards are in the bill to make sure that doctors aren't subjected to civil lawsuits for damages for providing necessary care that they believe is lawful under the statute, including emergency care or cancer treatment, but the person who is impregnated, the woman sought the care, does not?
Representative Greco.
Thank you, Mr. Speaker. Thank you, Representative, for the question. So in this bill, under lines 64 to 71, the bill states that notwithstanding any other provision of this act, a wrongful death action for the death of an unborn child may not be brought against the mother of the unborn child or against a healthcare provider for lawful medical care provided in compliance with the applicable standard of care, including but not limited to care related to assistive reproductive technologies provided with the consent of the mother.
Representative Harris.
Thank you, Mr. Speaker. And per this bill, what is the definition of lawful?
Representative Greco.
Thank you, Mr. Speaker. Thank you, Representative, for the question. This bill does not have a unique definition of lawful. It would use the definition of lawful that we use everywhere else in Florida statute and throughout litigation.
Representative Harris.
Thank you, Mr. Speaker. So a doctor facing an emergency situation, what definition of lawful is he to use?
Representative Greco.
Thank you, Mr. Speaker. Representative, thank you for the question. Again, this bill does not change the definition of lawful or have a unique definition of lawful different than the definition of lawful found elsewhere in and used elsewhere in Florida statute.
Representative Nixon.
Thank you, Mr. Speaker. Rep, if a surrogate loses a pregnancy, could a wrongful death action for damages from being brought against the surrogate by the biological father, for example?
Representative Greco.
Thank you, Mr. Speaker. Representative, thank you for the question. The answer to that's going to hinge on whether this is a traditional surrogacy or a gestational surrogacy. In the case of a traditional surrogacy, the surrogate mother, for all intents and purposes, is the mother of the unborn child up to and including birth. In fact, under current Florida law, 48 hours after the birth in a traditional surrogacy, the surrogate mother could retain custody of the child. So for the purposes of a traditional surrogacy, the mother would be treated like the mother throughout the rest of this action, and thus could not be the subject of a lawsuit under this bill.
Representative Gant.
Thank you, Mr. Speaker. Would a birth certificate be issued for the fetus?
Representative Greco.
Thank you, Mr. Speaker, and thank you for the question. I do not believe so because, again, we're talking about the wrongful death of an unborn child. There is no birth in this case.
Representative Gant.
Thank you, Mr. Speaker. On a death certificate, what would be listed as the date of birth for the fetus?
Representative Gant, he's already answered that he doesn't believe a death certificate would be issued. Do you have another question? You're recognized.
Mr. Speaker, for clarification, I asked what would a birth certificate be issued, and then this question said a death certificate. On a death certificate, what would be the date of birth listed on the death certificate for a probate to be opened for the fetus to be labeled as a decedent?
My apologies. You're correct. Representative Greco.
Thank you, Mr. Speaker. Representative, thank you for the question. Again, we're talking about an unborn child here, so there would be no date of birth.
Representative Gant.
Thank you, Mr. Speaker. Would a fetus have to, or would the parents or parents of a fetus have to apply for a social security card in order for the process of probate to be effectuated properly?
Representative Greco.
Thank you, Mr. Speaker. Thank you, Representative. I do not believe so. The Social Security Administration is a federal institution, so I would not speak on their behalf. But no, Representative, I do not believe so. And again, because we're talking about an unborn child here, there is no birth. This is not an individual who would be eligible to receive a Social Security number.
Representative Escamani.
Thank you, Mr. Speaker. Rep. Greco, if a patient gets abortion medication from their friend and her abusive partner finds out, could he sue her friend?
Representative Greco.
Thank you, Mr. Speaker. Representative, are you talking about an illegal distribution of a prescription medication?
Representative Escamani.
Thank you, Mr. Speaker. No laws are being broken.
Representative Greco, does that answer your clarifying question? You're recognized.
Thank you, Mr. Speaker. Representative, I'm not sure that I understand how we would get to a factual scenario that you just described without violation of Florida Statute 390.0111.
Representative Escamani.
Thank you. What if the abortion pills were provided in a different state?
Representative Greco.
Thank you, Mr. Speaker. Representative, if what you're discussing is lawful medical care, is that the woman goes to her physician and is prescribed these pills, or goes to another state where the distribution of the pills is lawful, this bill would not be applicable.
Representative Escamani.
Thank you, Mr. Speaker. Thank you, Rep. Greco. We've seen cases where states are seeking to prosecute doctors out of state who provide safe and effective abortion medication. So under your bill, could someone bring a wrongful death suit against a provider in another state?
Representative Greco.
Thank you, Mr. Speaker. Thank you, Representative, for the question. This bill cannot be used against a healthcare provider for lawful medical care provided with the consent of the mother, whether that medical care were in the state of Florida or in another state.
Representative Bartleman.
Thank you, Mr. Speaker. I just want to piggyback on that question. Where in the process is the lawful medical care determined to be lawful? Is it front-loaded before it goes to court, or would it be during that jury trial?
Representative Greco.
Thank you, Mr. Speaker. Thank you, Representative. Any factual determination would belong to the jury in the course of litigation.
Representative Bartleman.
So if I am Publix, if I am a doctor, if I am Amazon, any store chain, people then would have the opportunity to sue me over lawful, and that would then have to be decided in court. If that's what you're saying, what would that do to the liability insurance rates in the state of Florida?
Representative Greco.
Thank you, Mr. Speaker. Thank you, Representative, for the question. I don't know that I quite followed. Could you rephrase it? I don't understand what you're relating there with lawful medical care versus non-medical businesses.
Representative Bartleman for the last question.
Thank you. So my point is, for you to understand, is that anything that's going to be determined on your bill in terms of a court case has to be determined after the lawsuit is filed and after it goes to court. So people file lawsuits all the time in the state of Florida. We deal with it. Here, we pass laws to prevent frivolous lawsuits. So every time someone has a miscarriage, which is 20 to 30% of women have miscarriages just naturally, someone can claim it was because of unlawful medical care. So they can file the claim even though, it might have been pre-pregnancy, pre-prom. But then that doctor or that provider, or in any scenario, they would still have to go to court, hire lawyers, defend themselves. And I'm asking, what does that do for liability insurance in Florida, knowing that 82,581 women miscarried in Florida in 2022?
Representative Greco.
Thank you, Mr. Speaker. Thank you, Representative, for the question. In any of these cases, if you have a mother who miscarries and she feels that her miscarriage is the result of negligent medical care, and because she feels that the loss of her pregnancy was the result of negligent medical care, and she files a lawsuit, the defendant in that lawsuit would obviously probably contest that it's negligent medical care, but whether that medical care was negligent is the entire basis of the lawsuit. That is the factual determination that the jury would have to make in order to determine whether this was, in fact, a miscarriage due to negligent medical care.
Time for questions has expired. We're going to pause briefly for some recognitions. Representatives Overdorf and Trabulsi, you are recognized for a recognition.
Thank you, Mr. Speaker. Representative Overdorf and I would like to welcome Tom Jones, president of our St. Lucie County Education Foundation, and his wife, Beverly, to the East Gallery. Thank you for all you do to support the students of St. Lucie County.
Representative Hunchofsky, you're recognized for a recognition.
Thank you, Mr. Speaker. In the East Gallery today is my dad, John McGuire. Born in England, was sent to Ireland during World War II to live with his grandmother. He came to the United States, served in the Army Reserves for 6 years, became a citizen. He's 87 years old. The last time he was here was during COVID, so I'm just so excited to have him here. And welcome, Dad, to the Florida House.
Welcome to the Florida House. Are there any amendments?
On the desk, Mr. Speaker.
Read the First Amendment.
Representative Harris offered the following amendment with title amendment, barcode 711845, remove lines 64 through 71 and insert an amendment.
Representative Harris, you're recognized to explain your amendment.
Thank you so much, Mr. Speaker. Simply, my amendment ensures that no wrongful death action can be brought against the person who is pregnant, their healthcare providers, or their friends and families in connection with an abortion or other medical treatment. And that is the amendment.
Questions on the amendment? Representative Cross.
Thank you, Mr. Speaker. Representative Harris, what would be the impact of passing this bill without this amendment?
Representative Harris.
Thank you so much, Mr. Speaker. Thank you, Representative. That's a really good question. So the implications are, if you have a friend, say, who was assaulted and became pregnant due to that assault, and you wanted to be there for her and you wanted to drive her to get health care, reproductive health care, the person who got your friend pregnant, regardless of consent, could sue you for driving your friend there and being supportive of her. And we want to just ensure that people can still be there for their friends in a time of need without the fear of having liability on them.
Representative Cross.
Thank you, Mr. Speaker. Thank you, Representative Harris. Wanted to talk about the component of the woman who is carrying that child. Doesn't this bill already carve out women from a cause of action, and how would your amendment change this?
Representative Harris.
Thank you so much, Mr. Speaker. Again, thank you so much, Representative, for that really good question. Again, we understand that the person who is pregnant is exempt from liability. However, friends and family, doctors, medical providers, anybody that could impact or be a cause of the end of that pregnancy could be liable for civil liabilities. And we want to ensure that somebody who is helping their friend or a family member is exempt from that.
Representative Escamani, do you have a question? No. Oh, sorry. Representative Bartleman.
Thank you, Mr. Speaker. Representative Harris, is there anywhere in the bill that says the mother has to consent for a person who's impregnated, give consent to the person who impregnated her to file the case? Is that in the bill?
Representative Harris.
Thank you, Mr. Speaker. No.
Representative Bartleman.
So just a follow-up. So if I'm raped and my rapist wants to contest things and go to court, I can't say no to that. He just gets to do that?
Representative Harris.
Thank you, Mr. Speaker. There is no clear definition of parent. So therefore, somebody who has sexually assaulted somebody and got them pregnant could bring a case against a medical provider or a friend, anybody who was involved in the ending of a pregnancy.
Further questions on the amendment? Seeing none, are there amendments to the amendment?
None on the desk, Mr. Speaker.
Is there a substitute amendment?
None on the desk, Mr. Speaker.
We're in debate on the amendment. Representative Escamani.
Thank you, Mr. Speaker. I just want to thank Representative Harris for this amendment. I think what you are doing so eloquently is highlighting the risk associated with this bill if we do not put these amendments in. And despite the Q&A segment, I think it's very clear that we're in an atmosphere where there are individuals that we've seen in other states abuse the same type of language to create harm for women who are seeking access to abortion care or for those who are helping them or providing that care to them in very delicate and sensitive situations. And so I thank you for the amendment.
Further debate on the amendment. Representative Bartleman.
Thank you, Mr. Speaker. I want to point out that similar bills that have passed in other states have caused problems. For instance, in Texas, the man who impregnated a woman sued her friends who drove her to the clinic for $1 million each. Now, in any lawsuit, a lawsuit can always be frivolous. The doctor could win the lawsuit. But the problem is that you have to go through the litigation process. And so now anyone who impregnates someone can say, oh, Your mom drove you to the hospital after I raped you. I'm going to sue her. Now, whether or not he wins that lawsuit, he may not. But the healthcare provider, that hospital, that mother, they still have to pay money to defend themselves. And I have spent the last 5 years in this chamber hearing everyone talk about frivolous lawsuits against insurance companies, about people getting their roofs for no reason, about car insurance, because the people of Florida are litigious and we're trying to reduce those rates. You're opening up a loophole here. Think about Publix, think about every provider. I walk into a store and I may accidentally just bump a little bit, and then a month later I lose my pregnancy. I could have grounds to go back to Publix and say, that's because of that bump in that aisle. And it doesn't matter that Publix would win the lawsuit. They have to pay for the litigation of that lawsuit. And I'm speaking of the father, not the mother, I apologize. The father says that, or the man who impregnated her. I just feel like this is, if you look, when this bill has been passed in other states, if you look at the cases, you don't want to do that. You don't want to do that to the state of Florida. It has to have guardrails, it has to be smart, and this is just opening up Pandora's box, and you're going to impact every company, every medical provider. And for the rural counties in the room, we've already lost OBs, GYNs. No one wants to practice in this state. You open up this, we're going to lose more and more of those doctors. And I have 2 daughters who live in this state that need medical care. So I urge you to vote up on this amendment. Thank you.
Further debate. Representative Miller.
Thank you, Mr. Speaker. This amendment would give blanket immunity to anyone involved in an abortion, even an illegal one, or one where the physician or unlicensed person was negligent or reckless. Additionally, this amendment prioritizes the surrogate over the mother in a case of gestational surrogacy. It would also protect a surrogate who is negligent from responsibility for her actions. And for that reason, I ask you to vote no on this amendment.
Further debate. Representative Harris, you're recognized to close on your amendment.
Thank you so much, Mr. Speaker. There are already criminal penalties for illegal acts. So this amendment isn't to protect illegal actors. I didn't file this amendment to be smart or to play a game. I filed this amendment because I have a daughter, and she's 28 years old. And being a woman in this world is dangerous. And she can take all the precautions and she can do all the things. She can watch where she is at night. She can carry mace, she can carry pepper spray, she can take 1 million self-defense classes. But the reality is there's a possibility that she could be sexually assaulted and she could become pregnant. And if that happened and she wanted to end that pregnancy, or even if she wanted to continue that pregnancy, but something catastrophic happened, and she needed medical care that would end that pregnancy, I want to make sure that the people she trusts, the people that she loves, and the people that are providing her health care have a pathway to save her life or help her out. That's all this is. This amendment is to protect people like my daughter. That is my intention with this amendment. And I encourage everybody, whether you have a daughter or not, to vote up on this good amendment, this protective amendment. Thank you, Mr. Speaker.
All those in favor say yay. Those opposed, no. Show the amendment is not adopted. Read the next amendment.
Representative Escamani offered the following amendment, barcode 601-709. Remove lines 65 through 71 and insert an amendment.
Representative Escamani, you're recognized to explain the amendment.
Thank you so much, Mr. Speaker. Members, we just heard some commentary on the House floor pertaining to abortion care, and yet I've heard the bill sponsors say in committee many times that this isn't supposed to impact abortion care. We've provided a carve-out in this legislation as it pertains to fertility treatments because of concern that it could impact fertility treatments. And so all this amendment does is mimic that effort to say, let's also ensure that abortion is carved out, because we've heard stories about how bills like this have led to abusers suing friends and family members who help an ex-partner access an abortion. And so again, if we, this body, actually intend that this bill is not meant to deal with abortion access, then we should explicitly carve that out. And that is the amendment, Mr. Speaker.
Questions of the sponsor, Representative Gant.
Thank you, Mr. Speaker. Rep. Escamani, will your amendment limit the amount of bad actors who abuse this bill?
Representative Escamani.
Thank you so much, Mr. Speaker. Thank you for that question, Representative Gant. Yes, that is the goal, is to prevent frivolous lawsuits and to prevent harm being born out of this bill when it comes to women making personal decisions under Chapter 390, under the law, which is already very restricted in our state.
Representative Leader Driscoll.
Thank you, Mr. Speaker. Rep. Escamani, are you worried that if this amendment doesn't pass, that it might impact abortion access?
Representative Escamani.
Thank you, Mr. Speaker. Thank you, Leader. Absolutely. In fact, we've seen this bill many times. This is the third time that we've seen this bill. And we know back in 2024, the legislation was stalled following the Alabama ruling that impacted IVF access in their state, and it was due to legal language that was very similar to what's in this bill. And so we also have to remember that no legislation exists in isolation. And so I am very concerned about a potential use of this bill, knowing our state Supreme Court and some of their past statements and positions on abortion care. And I also be remiss if I didn't acknowledge that overwhelmingly Floridians don't want us to continue to ban abortion access. In fact, folks might remember that nearly 57% of Floridians voted yes on Amendment 4, which would have repealed the state's near total abortion ban. And so I think it's important to respect the will of the voters and to stop going down this path.
Leader Driscoll.
Thank you, Mr. Speaker. Rep. Escamani, you've touched on this a little, but could you tell us specifically why abortion needs to be mentioned?
Representative Escamani.
Thank you so much, Mr. Speaker and Leader. And it's very vague, right? The vagueness of and the broadness of this policy being proposed could absolutely create uncertainty when it comes to doctors and nurses who are already facing a legal landscape where they have to consult lawyers before they can provide life-saving care to patients. And so we already have an ecosystem that I would argue is not in the best interest of delivering patient care and respecting the privacy of that patient. And so I don't want to make a bad situation worse. And we've already carved out IVF fertility treatments because of the risk. And so we should do the same thing for abortion care.
Further questions? Seeing none, are there amendments to the amendment?
None on the desk, Mr. Speaker.
Is there a substitute amendment?
None on the desk, Mr. Speaker.
We're in debate on the amendment. Representative Gant in debate.
Thank you, Mr. Speaker. Rep. Escamani, I want to say thank you for always being a tireless advocate for bodily sovereignty for women. The fact that we sit here and we continuously have to humanize women as individuals and as people with brains that can make our own decisions is actually really insane. But what's even more insane is that we get in here and we talk about unintended consequences all the time, when just like with the vouchers, right? We said we need accountability measures and we see millions and millions of dollars unaccounted for. This is also going to cause very much intended consequences. And so it frustrates me and many of us that there's no process really, right? Because a good idea should be a good idea. And a good idea and policy should be policy that helps Floridians and not is detrimental to them. So this amendment is a great idea, and this amendment is actually good policy. So thank you for this good policy and for actually engaging in the process that I wish was actually a process.
Representative Persons Malika.
Thank you, Mr. Speaker. Members, the bill already addresses lawful medical care. The only thing this amendment does is encourage substandard medical care. But more troubling is that this amendment actually removes language from the bill that says you can't bring an action against the mother. So what this amendment does is it exposes the moms to liability if the child is lost due to the mother's negligent act and it wasn't connected to an abortion or reproductive care. Members, please join with me in voting against this amendment.
Leader Driscoll.
Thank you, Mr. Speaker. I'll be voting up on this amendment and would encourage everyone to do the same. As I read the amendment, I don't see where it opens up liability to the mothers as is being debated. But what concern I do have is when I speak with OBGYNs from around the state, and if you haven't talked to them, I encourage you to do that, to hear what is going on in their exam rooms, what is going on in the ERs, what's going on in delivery rooms. There's a lot of confusion that was caused by prior abortion access bills that this body passed. A lot of confusion. There are women who are being turned away because they can't get care for miscarriages because the doctors are concerned about liability. What I do see in this bill is that abortion access could be limited or harmed if we are not clear and carve out what Rep. Escamani is trying to do in this bill. So I would encourage us to, yes, think about women, yes, think about the lives of the mother, and let's do something that could make this bill, which I disagree with, but maybe we could make it just a little bit better and more clear for the providers and save some lives. So I'll be up on this bill. Thank you, Mr. Speaker.
Representative Hinson.
Thank you, Mr. Chair. Mr. Speaker, Representative, I would like to call your attention and to your colleagues' attention that the U.S. Congresswoman that represents my district went to the emergency room in Gainesville, Florida, because she had a systemic or what is it called? A septoptic pregnancy, and she was turned away because of this fear, and she almost died, catcamic, and she had to call the governor of the state of Florida to get medical care because of this fear. She has a baby now, praise the Lord, but so she wants to be a mother, but she doesn't want to die trying to be a mother. And what you're creating with this bill is the fear of death. Thank you, Mr. Speaker.
Representative Bartleman.
Thank you, Mr. Speaker. I think it's interesting that you carved out IVF because when the lawsuit happened in the one state and it shut down all the IVF providers, the state flipped out. But you're not going to carve out abortion when in the state of Florida, it's currently legal to get the abortion before 6 weeks. What you are creating, and I'm going to say this again, it's not about winning the lawsuit. It's about the liability, the insurance, having to defend it. If I go to an abortion clinic at week 3 and get an abortion, and the person who impregnated me now wants to file a lawsuit, I wouldn't know I was pregnant at week 3, I'm gonna go week 4, and files or 5 or 6, so whatever it is. If they go and file a lawsuit, the provider has to contact their insurance company. That doctor, it's a ding. The clinic has to contact their insurance. It's a ding. They have a sonogram that shows it was a legal abortion. They have to go to court. They have to defend themselves. They have to hire a lawyer. There will be a lawyer that's willing to take the chance to make a couple of dollars if they settled for that guy who impregnated the woman. You are opening up Pandora's box for lawsuits in the state of Florida. And I am serious. There are not enough OBGYNs here. They're not enough. They're leaving. They closed a birthing center at the University of Miami in Jackson, which associated with Jackson Health. What are we doing here? People don't want to work in this state. I'm going to be afraid to do anything if I'm an OBGYN provider, to know that now I'm going to give a lawful abortion to a woman, but the guy who impregnated her can still put that ding on my record, still activate my malpractice insurance. It's ridiculous. Carve it out. If it's legal and they're doing it right.
Representative Bartleman, time for debate has expired. Please wrap it up.
No, it's okay. I'm going to let Anna wrap it up. You know what I'm saying here. You're a lawyer. You know how lawsuits go. Thank you very much.
Representative Escamani, you're recognized to close.
Thank you so much, Mr. Speaker. And thank you to my incredible colleagues and your powerful debates. And I do want to emphasize this point that Rep. Bartleman was making. It's not so much that the lawsuit's going to be successful, it's the fact that you're filing a lawsuit in the first place. And I don't know if anyone, well, I'm sure folks here have been sued. I have had to sign for lawsuits before when I worked at Planned Parenthood, and I've been involved in many lawsuits myself. It is a costly experience, it's a challenging experience, and it's designed to quell people. It's designed to push people out. It's designed to force a doctor to not provide care, to leave the state, to make decisions based on what the lawyers downstairs think, not what their education tells them to do, right? And so ultimately, it's really important to remember that this legislation it is expanding Florida's Wrongful Death Act to apply to fertilized eggs. There's no way that does not impact abortion access. And Representative Miller in the previous amendment said the quiet part out loud to Rep. Harris and her concerns about her amendment impacting abortion providers. I mean, just because the bill sponsors say the word abortion doesn't mean it doesn't impact abortion. And abortion is healthcare. And it's really important to respect doctors in a state ecosystem where they're already restricted and not to make a bad situation worse. We gave a carve out for IVF and fertility treatments for a good reason. We should do the same thing for abortion access. Thank you, Mr. Speaker.
All those in favor of the amendment say yay. Yay. Those opposed, no. No. Show the amendment is not adopted. Members, we're going to pause briefly. Representative Oberdorf and Trabolsi, you're recognized for a recognition.
Good morning, members. On behalf of Representative Trabolsi and myself, we wanted to recognize in the East Gallery the fire chiefs from the absolute best fire district in the entire state of Florida, from St. Lucie County, the fire chiefs. Welcome them. Thank you, gentlemen, for your service.
Welcome to the Florida House. Members, we're out of practice. Please don't forget to put the pages to work. Read the next amendment.
Representative Escamani offered the following amendment with title amendment, barcode 557409. Remove lines 65 through 71 and insert an amendment.
You're recognized to explain your amendment, Representative Escamani.
Thank you so much, Mr. Speaker. If you didn't like that one, maybe you'll like this one. So this amendment specifies that cause of action cannot be brought without the consent of the mother, and also cannot be brought against a healthcare provider who has, again, not been convicted of a crime in connection with the care they provide. So this basically just tries to eliminate frivolous lawsuits and protect doctors who are following the law from not being caught up in litigation.
Questions of the sponsor? Are there amendments to the amendment?
None of that is, Mr. Speaker.
Is there a substitute amendment?
None of that is, Mr. Speaker.
Any debate on the amendment? Representative Persons-Mullica in debate.
Thank you, Mr. Speaker. Members, I encourage you to vote against this amendment as well. The bill already prohibits a cause of action when lawful medical care is provided. This amendment would give a pass for any medical negligence committed and require responsibility only when a crime is committed. That's a different standard. These are civil lawsuits. And shouldn't be subject to that heightened criminal standard. Please join me in voting against this amendment.
Further debate? Representative Bartleman in debate.
Again, thank you very much, Mr. Speaker. This is, if the mother believes she has medical standing because of something happening, like you're in a car accident or there's malpractice, the mother's going to sue. This gives the person who impregnated her the ability to sue, even if she's not filing a lawsuit, because she doesn't consent to it. And once again, all of this is determined in a court of law. And I wish, that you need to sit down with your doctors and talk about the real implications of this and their liability insurance. What I am also very afraid of is that if my daughter is pregnant and she breaks her wrist and she goes to the hospital and now sees just a general doctor, that doctor is going to be afraid to treat her. Because if 3 weeks from the wrist incident she loses her pregnancy, the father or the person who impregnated her can say, oh, it's because of the wrist injury. Like it really, I don't understand. Our philosophy in this House has been we don't want to make a way for frivolous lawsuits or to increase insurance carriers' costs. I voted for one of those bills. I didn't vote for all of them. Some of you did. But you're opening up such liability for the doctors. So I can't understand why we're doing this. I'm urging you to vote up on this because it's a free-for-all. People are going to just sue. And not only that, the doctors are going to leave the state. Thank you, Mr. Speaker.
Further debate on the amendment? Seeing none, Representative Escamani, you're recognized to close.
Thank you so much, Mr. Speaker. And I just wanted to emphasize that the reason why this amendment carries so much value is because as the way the bill is currently written, it discusses providers of lawful medical care, but the reality is that lawsuits for limited damages can be brought by simply alleging wrongdoing. And so though I appreciate the comments made when it comes to a different standard, I'm open to suggestions to make the amendment better, but ultimately the way the bill is currently written is that it creates an environment where ERs, medical doctors, nurses are going to be exposed to frivolous lawsuits. And we already know that the malpractice insurance rates and the costs for OBGYNs are some of the highest in this state. And so we're creating an ecosystem where those different providers are going to leave, and they already are leaving. I mean, I can't even begin to tell you how many medical students I talk to who are not planning to practice as an obstetricianist in Florida because they don't see a safe way to do that. And the number of families and parents that I meet who don't feel comfortable raising children in Florida or giving birth in Florida because of our legal landscape and how we've intersected politics into sensitive topics like reproductive care. And so for those reasons and more, I encourage members to vote up on the amendment. Thank you, Mr. Speaker.
All those in favor of the amendment say yea. Yay. Those opposed, no. No. Show the amendment is not adopted. Read the next amendment.
Representative Campbell offer the following amendment with title amendment, barcode 800927. Remove lines 66 through 71 and insert an amendment.
Representative Campbell, you are recognized to explain the amendment.
Thank you, Mr. Speaker. Members, my amendment adds perinatal professionals to the list of individuals against whom wrongful death action for an unborn child may not be brought when care is provided with the consent of the mother. This amendment simply ensures that professionals who provide supportive and community-based care during pregnancy and postpartum, often to the most vulnerable families, are not exposed to civil lawsuits for doing the work for which they are needed. This amendment protects the people who help make pregnancy safer, healthier, and more equitable. That is an amendment, Mr. Speaker.
Questions of the sponsor? Questions of the sponsor? Are there amendments to the amendment?
None of the desk, Mr. Speaker.
Is there a substitute amendment?
None of the desk, Mr. Speaker.
Is there debate? Representative Abbott, in debate.
Thank you, Mr. Speaker. Members, this amendment opens up the mothers to less than standard care with no recourse because it provides a blanket exemption for the perinatal professional organizations. Folks like doulas, lactation consultants, nutritionists, dietitians, mental health specialists, any licensed and non-licensed professionals. And what this does is because the mother signed a letter of consent, it allows them to provide any type of care. And even if they provide a negligent care, because of this blanket exempt, there is no recourse for the mother. The sponsor of the bill did a great job of protecting mothers, and I'm afraid that this amendment would put mothers in harm because there would be no recourse for any type of activity or unstandard care. So, members, I've asked for your no vote on this amendment.
Further debate? Representative Campbell, you're recognized to close on your amendment.
Thank you, Mr. Speaker. Members, this amendment asks a simple question. Who do we want standing beside women during pregnancy? More support or fewer people willing to help? Perinatal professionals are allies to safety. They show up in our homes, in clinics, in communities long before a crisis occurs. They reduce the risk, they save lives. If this bill exposes them to lawsuits for outcomes they do not control, the message we send is clear. Help at your own risk. When that help disappears, it is not lawyers who will feel the loss. It is mothers, babies, and families. This amendment strengthens care. It preserves common sense, a novel concept. Our job here is to do no harm. This amendment ensures that at least one group won't be harmed by this bill. Members, supporting women and families through pregnancy should never be a legal liability. I ask for your support of this great amendment.
All those in favor of the amendment say yea. Yay. Those opposed, no. Show the amendment is not adopted. Read the next amendment.
Representative Nixon offer the following amendment with title amendment. Barcode 443711. Remove line 66 and insert an amendment.
Representative Nixon, you're recognized to explain the amendment.
Thank you, Mr. Speaker. This is a very simple pro-family amendment. The sponsor's bill as written ensures a right of action cannot be brought against the mother, but a gestational surrogate could be subject to a lawsuit. My amendment simply ensures that an action cannot be brought against a surrogate. Gestational surrogate, as defined in statute 742.13, means a woman who contracts to become pregnant by means of assisted reproductive technology without the use of an egg from her body. That is the amendment.
Question to the sponsor. Is there an amendment? Representative Bartleman.
Thank you, Mr. Speaker. I actually know a lot of people who that's the only way they can get pregnant is through a surrogate. So is your concern that if I'm a surrogate and they think I eat the wrong thing or do the wrong thing, that they could sue me and then it would maybe not want me to be a surrogate? What is the impetus for this again? I want to give you time to explain that.
Representative Nixon.
Thank you, Mr. Speaker. Yes, that is the concern. If something happens, you know, when you lose a child, you get a little angry. And as someone who has lost a child, I got angry, and you try to figure out who's to blame. I was actually in a car accident once while I was pregnant, and I lost a baby. So I was very angry at the driver that hit me. So I could only imagine as a mother who would contract out a surrogate if they happen to lose a child. Like sometimes they may want to place blame on someone, and it may not be that mother's fault, that surrogate, that gestational surrogate's fault. And so I just want to look out, you know, for that woman who decided to actually put her life on the line, because when you have a baby, you come very close to death. And as many of you may know, Black women are 3 times more likely to die in pregnancy, given, you know, during childbirth. And so I'm just looking out for the well-being of someone who wants to bring a life into this world.
Further questions? Is there an amendment to the amendment?
None on the desk, Mr. Speaker.
Is there a substitute amendment?
None on the desk, Mr. Speaker.
Is there debate on the amendment? Representative Burfield.
Thank you, Mr. Speaker. Members, I encourage you to join me in voting against this amendment. The amendment seeks to actually undermine the intent by providing a blanket form of immunity for gestational surrogates or a carrier of a pregnancy via surrogacy, even if their actions are negligent or intentional. In other words, bad actors or negligent surrogates should not be afforded blanket immunity for liability for such horrible actions. So I encourage you to not support this amendment, because if we do, it would be negligent on our part.
Further debate? Representative Nixon, you're recognized to close.
Thank you, Mr. Speaker. That simply is not true. This is just simply giving the gestational surrogate the same type of, it's allowing them to get the same types of protections that a mother could have, which is something that you already outlined in this bill. And so why not provide the same type of protections for someone who decided to put their life on the line to carry someone else's child? Choosing to become a surrogate is one of the biggest, most personal decisions someone can make. They may go through extensive background screenings and then navigate the complex conditions of pregnancy, all to support others in expanding their families. If this bill passes without my amendment, we could see increased liability, fear, and blame placed on surrogates, which could lead to a massive decrease in those willing and able to go through the process. Can you imagine a single woman who becomes a surrogate, a gestational surrogate, who also then gets into a relationship, finds out later that her partner is abusive, maybe gets beat up and loses that child, And now, because the parents are so upset that she stayed in a relationship with someone who is abusive, they now want to sue her. What type of message are we sending to people who are really looking out for other folks? That's just wrong, y'all, for real. No family looks the same, and as legislators, we should not be getting in the way of people making physical and financial sacrifices in order to have children. If y'all really are pro-life, you definitely vote up on this bill. Thank you.
All those in favor of the amendment say yay. Those opposed, no. Show the amendment is not adopted. Read the next amendment.
Representative Rayner offer the following amendment, barcode 301915. Remove line 67 and insert an amendment.
Representative Rayner, you're recognized to explain the amendment.
Thank you so much, Mr. Speaker. And just for clarity, members, there is a substitute amendment that fixes a clerical error. Instead of lines 67, it should be 66, but nonetheless, I will go ahead and explain. The amendment seeks to insert a clause that says, or without the consent of the mother. Basically, this amendment, right now, as the bill stands, it allows anyone who has impregnated someone to bring a lawsuit for about 2 years after the loss of the pregnancy. So once again, members, there's been concerns, and if y'all could lower the, thank you so much. Members, there are concerns that this bill will allow for bad actors to be able to bring a lawsuit with regard to a loss of the pregnancy. And also there have been concerns that have been eloquently outlined that this could be used to retaliate against women who have lost pregnancy. And for those who may not understand, and my colleague, Representative Nixon, talked about it, and I think that there's probably other individuals in this room that can speak to it, losing a pregnancy can be one of the hardest things that someone can experience in their lifetime. And many people have, many of our constituents have. So to suggest that losing a pregnancy, that someone could bring a lawsuit and do that without the consent of the mother is actually egregious. And so right now, the basis of this amendment is to literally include language that a lawsuit cannot be brought without the consent of the mother. And so, members, that is the amendment.
Question to the sponsor. Representative Tant.
Thank you, Mr. Speaker. Representative Rayner, what bad actors, can you give me some examples of what those bad actors would be? Or who they'd be?
Representative Rayner.
Yes, thank you so much, Representative Tant, for that question. I'm a trial attorney, so I like to give examples. And so say a person who was 5 days pregnant, slipped and fell into Publix, and then at her next doctor appointment 2 months later learned that she had lost her pregnancy. Her ex learns about this bill and sues Publix for unlimited damages. And I said ex, not their partner, an ex decides to sue Publix for unlimited damages, alleging that the slip and fall 2 months earlier led to the loss of the pregnancy. And they could bring the lawsuit up to 2 years after the pregnancy. Her ex could sue her employer, her midwife, her massage therapist, anyone he thinks of that or wants to blame for a miscarriage, and he can do that without her consent. And can you imagine if that woman was in an abusive relationship, her abuser now has the ability without her consent to be able to sue whomever they think and also drag her through litigation.
Further questions? Are there amendments to the amendment?
None on the desk, Mr. Speaker.
Is there a substitute amendment?
On the desk, Mr. Speaker.
Read the substitute amendment.
Representative Rayner offer the following substitute amendment, barcode 308391. Remove line 66 and insert an amendment.
Representative Rayner, you're recognized to explain the substitute amendment.
Thank you, Mr. Speaker. As mentioned earlier, this is just to correct a clerical error. Instead of line 67, changing it to 66.
Questions on the substitute amendment? Are there amendments to the substitute amendment?
None on the desk, Mr. Speaker.
Is there debate on the substitute amendment? Representative Jacques.
Thank you, Mr. Speaker. Members, this amendment would create a situation in which a third party can unilaterally stop litigation for somebody who does have standing to bring a case forward. This would prevent legitimate parties from seeking redress in our courts for the death of an unborn child, and for that, I ask you to vote down on this substitute amendment.
Further debate on the substitute amendment. Representative Rayner, you're recognized to close on the substitute amendment.
Do I waive? So I'm trying to think, do I waive close? It's the amendment. Thank you, Representative Skidmore. This is why we have you here. So I'm actually going to close on the substitute amendment. You know, members, the issue really becomes for me.
Rayner, hold on a second. Members, can you hold it down, please? Representative Rayner.
Thank you so much, Mr. Speaker. Members, the issue becomes for me that we talk about the sanctity of life, we talk about wanting to protect women, we talk about wanting to have people be able to make decisions for their bodies. Well, at least the Democrats do. And so the issue becomes for me that when we don't even allow a woman to even consent to a lawsuit being brought with regard to what has happened to her, and we are opening the door for bad actors. Many times the bill sponsor has said last year and this year that this bill is not an invitation for bad actors. However, when we've offered amendments, common sense amendments, to make sure we can close those loopholes based on what we've seen throughout the country, they get voted down, they get voted no. And I don't understand that if this is specifically about protecting unborn life, as you have said, or making sure that there is a cause of action, why we would not want to make sure that a bad actor would not have the ability to bring a lawsuit, and that if the mother is still present here on earth, that she would be able to consent about what's happening and going on with her body. Members, this is a very common sense amendment. I would say that if you choose to vote it down, you're saying the quiet part out loud, that the state of Florida actually does not care about the bodily autonomy and the bodily sovereignty of women. So I think that if you actually do care about that, you should vote up on this amendment.
All in favor of the substitute amendment, say yay. Yay. Those opposed, no. No. Show the substitute amendment not adopted. We're back on the main amendment. In debate on the main amendment. Representative Gant in debate.
Thank you, Mr. Speaker. Okay, so there's this word, it's ultra-crepidarian, okay? And it means opining on something as if you're an expert when you have no idea what you're talking about, okay? And people in this legislature, and government in general, they like to be very, the very definition of that word, okay? And so when we are talking about this bill or this amendment in particular, it is to address something that as attorneys, and that is our profession, we know that this is a reality. So it's not just us, wanting to be heard or to talk on the microphone or to get some new pictures on our little folder for members. It's actually about creating good policy. So Rep. Rayner, thank you for this amendment. Just because people say this won't happen, it's not actually true if it's not backed by factual statements. And this amendment is backed by facts in real life and in the practice of law. And I would encourage everyone to vote up on this amendment. Thank you.
Further debate. Representative Bartleman.
Thank you, Mr. Speaker. To me, this is one of the biggest problems with this bill, is that the mother is left out of the process. If I'm the person who was carrying the pregnancy and I'm the person who lost the pregnancy, and I don't think I'm going to sue Publix for getting bumped, or I don't think I'm going to sue the doctor who hurt my wrist, why is it the person who impregnated me, who could be a one-night stand, who could be someone I broke up with, who could be an abuser, could be someone I divorced, why should they be allowed to bring a lawsuit? Think about the litigation this creates. And this brings me to another case. There was already a case based on a bill like this in another state where the father, went to the abortion clinic with his wife, had the abortion, and then after they got divorced, sometime later decided, I'm going to sue the abortion clinic. Now, granted, as you said, if it was lawful, he's going to lose. But it's the litigation piece. It's the litigation piece that hurts doctors, that hurts clinics, that hurts insurance. And I have to tell you, a lot of times people just settle. That's what we see in the insurance industry. They just settle. So you sue the abortion clinic a year later, and they're like, we're just going to settle this case, and we'll give you $1,000, $5,000. This creates a huge loophole. In every case, the mother should be the one consenting to the lawsuit. Thank you, Mr. Speaker. I urge you to vote up on this good amendment.
Further debate. Representative Rayner, you're recognized to close.
Thank you so much, Mr. Speaker. And I love that I'm getting a second bite at this apple to close on this amendment. Members, and I will be talking about this a little bit more in the next amendment and then also my debate. But I will say this, if we do not give the mother the ability to consent, and especially this legislature, this body that talks about how we want to protect women, especially in domestic violence instances, and as my colleague Representative Gant said, that this is backed up by facts, you are opening the door for abuse to be perpetrated more so, more and more, even after someone maybe has left a relationship. And for that alone, we don't even have to talk about the other things, Publix or whatever, but for that alone, if we are actually concerned about protecting the women of the state of Florida, protecting pregnant people of the state of Florida, and you don't want to subject them to more abuse, this right here, this amendment right here, empowers these same women. So I'm asking you for that, to vote up on this good amendment.
All those in favor of the amendment say yay. Those opposed, no. Show the amendment is not adopted. Read the next amendment.
Representative Bartleman offer the following amendment with title amendment, barcode 591157, between lines 71 and 72, insert an amendment.
Representative Bartleman, you're recognized to explain the amendment.
Thank you, Mr. Speaker. My amendment is very simple, and it's very common sense, and it's about protecting our most vulnerable victims. Since I have served in this legislature, we have continuously prioritized the rights, safety, and mental health of victims of rape, incest, and human trafficking. This bill, as currently presented, would give rapists the ability to sue a medical provider or a clinic for damages for terminating a pregnancy that is a result of a sexual assault. Not only that, the rapist has the ability to sue the friends, family members, or parents of the victim who helped her or drove her to the clinic. If the victim's pregnancy ends in miscarriage, the same perpetrator has grounds to sue. I want to talk about this. These lawsuits, even if that perpetrator loses, it involves subpoenas, it involves testimony, it involves cross-examination, and that will continuously re-traumatize that victim to have her in the witness stand. My amendment simply excludes cases brought by a person whose involvement in the pregnancy was by means of rape, incest, or human trafficking. Rapists should not be fiscally rewarded for assaulting someone in the state of Florida. I urge you to vote for this amendment. Thank you.
Questions of the sponsor? Representative Woodson.
Thank you, Mr. Speaker. We're bottoming. This is an extremely important amendment, and I want to make sure you clarify something for me. Who would be impacted if we don't adopt your amendment?
Representative Bartleman.
People who would be, thank you, Mr. Speaker, I apologize. The person who would be impacted is the woman who is a human trafficking victim, the woman who is a victim of rape, the woman who is a victim of date rape, and the woman who is a victim of incest. Because as everyone has said on this floor, the lawfulness of the medical procedure is determined when the court case starts. I just supported an amazing bill in committee this week that doesn't allow a defendant to cross-examine a rape victim because it's so traumatic. Great bill. I hope it makes it to the floor. But what we're doing here is we're setting up new court cases where that, and maybe we need to pass that, but that victim will have to go through all of that. So let me explain the bill. The bill that we voted on, I want to be clear, I explained it correctly. In cases in court, the defendant can defend themselves. So there are cases where a rapist cross-examines, not the lawyer. This is to protect that victim because that whole process is so traumatizing. So now I'm suing, the rapist is sitting at the table and the lawyer's there and she's gonna have to relive, well, when did he rape you? Just imagine having to relive that whole experience and being asked questions. It's heart-wrenching. I don't understand why this body, and I hope he hasn't said it's an unfriendly amendment yet, why wouldn't you just support this to protect these victims? It's common sense. It doesn't take away from your intention of this bill. It just protects the most vulnerable people in Florida. Why put them through a trial so the rapist can make money? That's ridiculous.
Representative Woodson.
Thank you, Mr. Speaker. And Boderman, thank you for the clarification. While doing some research on this bill, I found out that 30% of sexual assault is reported in the military. 30%, which is low to me. What about members of the military also? Is that included?
Representative Bartleman.
Thank you, Mr. Speaker. It includes everyone who is a victim in the military. You should also know that every single minute someone is sexually assaulted in the United States, and every 9 minutes a child is raped. That's a lot of victims. And we want to not re-traumatize them because the only reason a rapist would be suing is because they want to make money. And so this is a no-brainer for this chamber, quite honestly. We need to protect victims. Thank you very much.
Further questions? Other amendments? You have Representative Persons Malika. Thank you.
Thank you, Mr. Speaker. Representative, there appears to be a vast misunderstanding as to the Wrongful Death Act. I shouldn't have to ask this question, but are you aware that only a personal representative of the estate of the child can bring a wrongful death action? And are you aware that already under our laws of the great state of Florida, we prohibit anyone convicted of a felony from being appointed as a personal representative? And rape, incest, human trafficking, those are all felonies.
Representative Bartleman. State your point. Representative Joseph, you're recognized.
Thank you, Mr. Speaker. Questions are supposed to be used to ask questions we don't know the answers to. That sounded a lot like debate.
She's asking if Representative Bartleman understands and knows the subject of her question. She does not know the answer to that question. Representative Bartleman, you're recognized. Representative Bartleman, you're recognized.
Oh, I'm not afraid to answer this question because, thank you, Mr. Speaker, because only 1 in 3 rapes are actually reported. This is national statistics. For every 1,000 sexual assaults, 50 reports lead to arrest. 28 cases lead to felony convictions, and only 25 perpetrators are sentenced to incarceration. So what's going to happen is they may not be convicted of their felony when they're filing this lawsuit, but they know the abortion took place. So those are the people that I'm protecting.
Representative Persons Malika.
Thank you, Mr. Speaker. Then, Representative, how do you think that's going to play out in a court of law? Your amendment has no evidentiary standards, no process. It only helps the defendant. And the defendant won't be the father. Defendant will be the person that caused the wrongful death of a child. That defendant will use your amendment to put the traumatized woman on the stand and ask her what happened. They'll try to use any loophole to not pay the mother for damages for losing her child. How do you see it playing out? Because I only see it re-traumatizing that woman.
Representative Bartleman.
Number one, thank you, Mr. Speaker, I don't defend rapists. And number two, there will be an arrest record report if it gets to that point, and the mothers defend. And remember, they can sue the mother, the father, and you know what I just thought about that I should have put in this amendment? Stealthing. What's to stop from someone taking their condom off, getting the woman pregnant, and then suing the abortion clinic? There are so many scenarios here. And lawyers, there are two sides to every story. And I have spoken to lawyers who have worked on this amendment with me. So what I would say is, where would be the harm in putting this amendment in? And then if you think that means because they're not convicted of a felony, I am willing to accept in a friendly amendment where it's an arrest report for incest, human trafficking, or sexual abuse to address your concerns.
Representative Persons Mullica.
Thank you, Mr. Speaker. Representative, again, I would ask you to tell me where in your amendment does it protect the woman who's been through enough trauma by being put on a stand by a defendant who caused the death of her child?
Representative Bartleman.
Thank you, Mr. Speaker. Where in this bill do you protect the victim of rape from being put on the stand? Thank you.
Time for questions has expired. Are there amendments to the amendment?
None on the desk, Mr. Speaker.
Is there a substitute amendment?
None on the desk, Mr. Speaker.
Is there debate? Representative Rayner in debate.
Thank you so much, Mr. Speaker. Members, if you vote down this good amendment by my colleague, Representative Bartleman, what you're basically saying, you're saying the quiet part out loud. You actually don't care about rape victims or rape survivors. You actually don't care about survivors of incest. You actually don't care about survivors of human trafficking, because this is a common sense amendment. We know that this happens. Actually, I would like to let you know that Florida actually leads the country in human trafficking. So these are very real things that are backed up by facts. This is not conjecture. And when we talk about what's going to happen in the court of law, it is laughable to me because my colleague, who is a lawyer, knows as well as I know, and I practice criminal defense, how many of these cases actually result in a conviction. And a lot of times, cases don't even get to a conviction, or don't even get to being investigated by a prosecutor. Sometimes a route that it does happen, that it does go, is a civil route. So all of these things of, well, what about this, what about that? Let's focus on protecting survivors of rape, protecting survivors of trafficking, protecting survivors of incest. If you vote down on this amendment, you're telling the people of Florida where you stand when it comes to that. So vote up on this amendment.
Representative Jacques.
Thank you, Mr. Speaker. As a former prosecutor who proudly prosecuted rapists, and as a policymaker who just last session passed a bill into law that now makes human traffickers eligible for the death penalty, I can appreciate the intent behind this amendment. The amendment, however, is very problematic, Mr. Speaker, because it does not include any sort of evidentiary standard to prove that the person being blamed for raping is guilty of the applicable offense. This would encourage the defendant to simply assert rape, incest, or human trafficking just to get out of being sued for something that they caused. And for that reason, we have to vote down this amendment.
Representative Persons Mullica.
Thank you, Mr. Speaker. Members, I know it's the first real day of session where we're on the floor voting on bills. What we do on this floor is we pass laws. We pass laws that have real impacts. And when we do that, we need to be thoughtful and we must be intentional. This amendment doesn't help women who have been through trauma. This amendment only benefits the bad actor that caused that woman to lose a child by giving them a loophole to go after the parents and create an issue and put that traumatized woman back on the stand and make her answer questions that she should never have to answer in order to recover damages for the loss of her child. The laws already say it. The only person who can bring an action is a personal representative. That's court appointed. And the laws already say a court can't appoint somebody convicted of a felony. And I don't see a court appointing somebody when the mom shows up at that hearing and says, hey, that guy committed rape, incest, or human trafficking. You really think the judge is going to appoint that person as a personal representative? But this bill This amendment does not seek to solve the problem that the amendment sponsor said she wanted to solve, and that was to not re-traumatize women. It would re-traumatize that woman, and if you vote for this amendment, members, you are committing legislative malpractice.
Representative Woodson.
Thank you, Mr. Speaker. I'm standing here as a former public administrator who oversaw a domestic violence program, one of the largest one in the state of Florida, in Miami-Dade County. And I saw these women who have been raped, those who were impacted as well by incest or human trafficking. And all Representative Boderman is asking us to do is carving out something for those who are impacted by rape or incest or human trafficking. That's all. Let's put our emotions aside. Let's do what's right, because I don't want to have to come back in this chamber and have to go back on this bill for us to realize the pain that we will be causing to those impacted by what she's trying to convey to us in this chamber. If we don't pass this amendment, we are giving control to those abusers. That's exactly what we will be doing. So I understand that we all are passionate about this issue, but all I'm asking us to do, let's take a minute and think about the amendment. Let's not just see the legalities that we're talking about. Yes, I know some of us are attorneys, some of us are not, but this amendment is clear. It is simple. So I understand the bill. Some of us want to vote for it, some of us don't. But this amendment is critical in order for us to do right by those women who will be impacted by rape, incest, or human trafficking. That's the bottom line, and that's it. Thank you.
Time for debate has expired. Representative Bartleman, you're recognized to close on your amendment.
Thank you, Mr. Speaker. I respectively disagree with the assertion that a woman isn't going to be brought into a courtroom that a woman would be brought into a courtroom under my scenario. There is nothing in this bill that stops a person from suing a rapist, someone who commits incest, a human trafficker situation. There's nothing, no language in here that stops that. We thought that that language was so important that we even put that language in all of our abortion bills. That's like a cornerstone of what we do because we want to protect. Again, everything is decided in the court of law. It could happen under Jenna's scenario, Representative Persons Mullica's scenario, under my scenario. This exemption is so important. I kind of didn't understand how it was left out when we do anything in this chamber. We always carve out something for those victims, and I feel terrible that I didn't carve out anything for stealthing. As I said, court cases take years. 98% of the people the cases where there is sexual assault, those people do not go to jail. That's a problem. We need to protect the most vulnerable. They are going to have to go to court. They are going to have to relive it. If you simply put language in this bill that says, if it's any of these scenarios, you don't get to do anything. That's all we need. Why wouldn't we do that? I am not in the business of helping rapists and defendants and rapists and human traffickers and people who commit incest, and I'm not going to defend them here. Not only that, I'm not going to help them get rich. And that's even a bigger problem. They have no grounds to ever sue in any scenario. So I am asking you, this is, I think, one of the most important amendments we can pass today. Not only that, it's not just the medical provider. If your family member is brutally raped and you drive her to the clinic, or is a victim of date rape and you drive her to the clinic, and that case isn't moving, isn't going forward, but there's an arrest, they can sue the mother who drove her daughter, the friend who drove her daughter, There are situations where the rapist could say, hey, if you don't drop your criminal allegation, because these are not good people, if you don't drop your criminal allegation against me, then I'm going to go ahead and sue your family members for driving you to that abortion clinic. These are unscrupulous people, and you're creating a loophole for them. No rape victim should ever be re-traumatized. I have worked this out with attorneys who feel very differently than what you do. And so I am urging you to support this and carve this out. If anything, if you are an attorney and you saw there was an issue, I would have appreciated you to make it, I would take any friendly amendment to make this better. So why wasn't that even considered if we're all here for rape victims?
Thank you.
Please support my amendment. Thank you.
All those in favor of the amendment say yay. All those opposed say no. Show the amendment is not adopted. Sitting Representative Hunchofsky, Representative Gant, Representative Gottlieb, Representative Campbell, and Representative Young. The clerk will unlock the machine. Members will proceed to vote. The clerk will unlock the machine and announce the vote.
33 yeas, 78 nays, Mr. Speaker.
The motion is not adopted. Members, we're going to pause in the proceedings for some recognitions. Representative Valdez, you have 2 recognitions. You're recognized to do both.
Thank you very much, Mr. Speaker. In the East Gallery, I think they're gone by now, but we had Patty Rendon, Hillsborough County Public School Board member, who is about the hardest working school board member in Hillsborough County, and I just wanted to give her a quick hello, as well as the Alexander Rivera and Jim Clark with the Coalition of Churches. Thank you.
Let's welcome them anyway. Welcome to the Florida House. Representative Franklin, you're recognized for recognition.
Thank you so much, Mr. Speaker. Today is FAMU Day at the Capitol. I'd like to recognize some distinguished individuals in the West Gallery. First, the 13th president of Florida A&M University, Mrs. Marva Johnson. And I have a few more. I will recognize them kind of back to back here. We have the FAMU Board of Trustee Chairman, Chairman Devron Gibbons. We also have SGA President. Oh, go ahead. We also have the Student Body President, President Zayla Bryant. We have the FAMU National Alumni Association President, President Artisha Polk. We also have the newly appointed FAMU Board of Trustee member, Mr. Kenneth Jones. We also have Ms. Nia Mixon and the Baby Rattlers from FAMU Developmental Research School. And just to list a few great facts about Florida A&M University, we are the #1 HBCU for online study by Forbes Advisor as of 2025, the #1 public HBCU 7 consecutive years per the U.S. News and World Report, including 2026. We are also ranked in the top 100 public universities, period, per U.S. News and World Reports. Also number 22 for Social Mobility Index per the U.S. News and World Reports as of 2026. And we do well in athletics too. The 2025 Women's Track and Field SWAC, Southwestern Athletic Conference Outdoor Champions, the 2025 Women's Tennis SWAC Champions, and the first ever 2025 Men's Golf SWAC Champions as well, which I used to be a member of that team. Thank you so much and happy FAMU Day.
Welcome to the Florida House. Representative Hunchofsky, You're recognized for recognition.
Thank you, Mr. Speaker. In the East Gallery, I would like to recognize and welcome to the Florida House the students and Moms Demand Action. Thank you so much for being here and welcome to the Florida House.
Read the next amendment.
Representative Rayner offered the following amendment with title amendment, barcode 562551, between lines 71 and 72, insert an amendment.
Representative Rayner, you're recognized to explain the amendment.
Thank you so much, Mr. Speaker. Members, this amendment seeks to clarify that if a woman was experiencing abuse, her abuser cannot bring a lawsuit under this bill. As we heard in the last amendment, this is necessary protection to limit bad actors filing not only frivolous lawsuits, but to protect survivors from their pregnancy loss or abortion care from being weaponized against them in their support systems. That is the amendment.
Question to the sponsor. Are there amendments to the amendment?
None on the desk, Mr. Speaker.
Is there a substitute amendment?
None on the desk, Mr. Speaker.
Is there debate? Representative Bartleman.
Thank you, Mr. Speaker. It's a criminal thing. It's an abuser. I didn't hear any arguments against that right now. I'm just kind of curious that why it applies, why we give rapists and people who commit incest and human trafficking, you know, we think that this bill's gonna help them, but this wouldn't help in the case of abuse. That's why I think that argument is on its face flawed. But what I want to bring up is that we're going through this process, and it's not about a show. It's about like real people and real victims. And honestly, we wouldn't even have to have any of these amendments if the #1 amendment was passed, which was the mother consented. So if I was getting abused, I would not consent to the lawsuit. If I was a victim of rape, incest, and human trafficking, I would not consent to a lawsuit being filed. I wish we could really pound out in this chamber good policy. So if you're not going to make exemptions for people who are abusers, or people who are victims of rape and incest, I mean, wouldn't consent have been enough to fix all of the things we're talking about? I just don't understand when we write this policy why it always has to be like a big fight and we don't sit down and say what can really work. These are common sense things that just make a difference for people and make the legislation better. So I hope we're going to support this amendment, because if you're an abuser, again, you don't deserve to get rich off of this. Thank you.
Representative Harris.
Thank you so very much, Mr. Speaker. Representative Rayner, thank you for bringing this amendment. You know, I don't want to be repetitive, but I have to be, because what Representative Bartleman said is so true. If we had just given the person who is pregnant the consent, we would not have to go over all of these amendments to ensure that they are protected from harm, from re-traumatization, from abusers getting the ability to sue, even though they abused. And let's be so for real here right now. That's what these amendments do. They are protective. They protect the person who is pregnant. They protect her. They give her the power. They give that person the power to decide if they thought that they were wronged, they can sue. And I'm all for that. I am all for the person who is pregnant having the ability to sue, to bring damages. I am all for that. I will support that all day. But I am not for abusers. I'm not for human traffickers. I'm not for that. So thank you so much, Representative Rayner, for looking out, again, for looking out for Floridians and making sure their interests are protected and making sure that we can mitigate some of what this bill could possibly do in the future. Thank you.
Further debate. Representative Escamani.
Thank you, Mr. Speaker. I will not be repetitive. I just want to thank our colleagues for their testimony and Representative Rayner for this amendment. Look, if this bill wasn't so broad, we would not have to offer all these amendments, but there are some serious consequences as the bill is currently written, and we don't have to look far. We have examples in neighboring states where language like this has been used to punish women, to harass ex-partners, like in Texas and Arizona. And so please consider this simple amendment that just ensures that the woman at the heart of all of this is going to be safe. Thank you, Mr. Speaker.
Further debate. Representative Rayner, you're recognized to close on your amendment.
Thank you, Mr. Speaker. Members, without getting too personal, amendments like this are not only personal to me, but are personal to people, other folks who are in this room who may have experienced intimate partner domestic violence. And here's the thing that we understand. Most women do not report. Most women do not file charges. Most women don't even tell their closest family or friends. And this amendment simply says that if the abuse is documented through attestation from the mother. So we see y'all said no to the consent form part. Now someone wants to bring a lawsuit and the mother is able to attest that domestic violence has happened. This is not conjecture. This is not something that, oh, well, this may happen or this may occur. We have seen this in Arizona. We have seen this in Texas. And it should not take a woman having to lay bare her most horrific moments for us to understand and have a modicum of humanity. It should not take a woman having to attest to any type of abuse for us to be able to say, this is kind of common sense. We should actually maybe make sure that we protect women from further abuse. But yet, that's what we do here in the Florida House. You want women to be drugged through the worst experiences and have them relive the worst experiences because you want control over women's bodies. It's disgusting. And it's tired. And I'm tired. And I'm tired for the women of the state of Florida who have to be subjected to this foolishness. So this is a common sense amendment. Do not tell me you want to protect women and you will not vote up for this amendment. Do not tell me you want to protect some of the women that are in this house who have experienced this type of abuse and you won't vote up for this amendment because it's time out. This is a good amendment. Vote up on it. And if you're not, you're sending a message once again to the women of the state of Florida that you care not about them.
All those in favor of the amendment say yay. Those opposed say no. Show the amendment is not adopted. Read the next amendment.
None on the desk, Mr. Speaker.
Show the bill rolled over for third reading. Representative Greco, you're recognized for a motion. Representative Greco moves that the rules be waived and that CS for HB 289 be read a third time by title and placed on final passage. All in favor say yay. Yay. Opposed, no. Show the motion adopted. Read the bill a third time by title.
By Civil Justice and Claims Subcommittee and Representative Greco and others. CS for House Bill 289, a bill to be entitled An Act Relating to Civil Liability for the Wrongful Death of an Unborn Child.
Are there any amendments?
None on the desk, Mr. Speaker.
Members, we're going into structured debate on committee substitute for House Bill 289. Debate will be limited to 30 minutes per side in 15-minute increments. Total debate time not to exceed 60 minutes. Representative Gant, you are recognized in debate.
Thank you, Mr. Speaker. I yield to Representative Cross.
Representative Cross.
Thank you, Mr. Chair, or Mr. Speaker. Apologies. Members, I stand in opposition today to this bill, really to voice the concerns of Floridians, many of my constituents, who will be negatively impacted by this bill. With this legislation, we're headed down another slippery slope that weakens reproductive freedoms and damages people's confidence in accessing safe medical care. For medical professionals, the threat of unfettered legal action and its repercussions poses a risk to their ability to practice and to make decisions that affect people's health. I have heard from students in the medical professions who are trying to get their education here, but know that after they get their degree, they're leaving to go to other states because they don't feel like they can practice the way they are meant to and provide the safe medical treatment that their patients need and deserve. We've heard that some of the repercussions under this bill could be that a friend or a family member driving a woman to a reproductive health care clinic could be subject to a lawsuit. Even an Uber driver could be sued for driving a patient to receive medical care, or a grocery store if a woman slipped and fell in the aisles and down the road suffered a miscarriage. As state leaders, our decisions have to be multifaceted. This bill jeopardizes confidence in our medical community and is leading us down a treacherous path where people's medical freedoms are questioned and will eventually undermine vital health care services like IVF and reproductive health care. Time and again, this body has prioritized legislation that undermines the bodily autonomy of many Floridians. Members, it's time we stop attacking people who make different personal decisions than we may have, and the friends and family members who are just trying to support them during a difficult personal time. Please join me in voting no on this bill.
Representative Gant.
Thank you, Mr. Speaker. I yield the floor to Representative Harris.
Representative Harris.
Thank you so much, Mr. Speaker. So I want to take a step back and reframe this discussion and talk about this bill in the framework of medical care and abortion, but mostly medical care. I know everyone is very emotional about this, but I want to bring some facts and the background. So the way medical providers operate is that they have to act first and not worry about litigious obstacle courses that they need to jump through. And unfortunately, we already have a bill already in this state that has caused such a chilling effect for doctors that they literally don't know how to operate sometimes. I've spoken to doctors who have they practice here and then they practice in Maryland, and they said that the way that they practice medicine in this state versus the way they practice in Maryland is completely different. Because they said that in Maryland, when someone comes in with a catastrophic a miscarriage or something happening to the pregnancy, they just care. They just go into what they are trained to do. They go into being a doctor. But they said when they practice here, they have to think about what action that they're doing is going to come back, and are they going to be blamed? Are they going to get their license taken away? And it's difficult. And we have lost so many of these providers to the point that, like, when her daughter got pregnant and had to have an induction because she was, she had high blood pressure and edema, there were no doctors. There were beds, but there were literally no OBGYNs to deliver her child. She had an appointment. She was told to go home. She was told to go home because they said, we don't have enough care here. And if it's impacting a place like Central Florida, like Orange County, where we have doctors and emergency clinics and urgent cares literally on every corner, what is this going to do to the person in a rural county where the maternity wards are already closing because we already put into law things that are making it difficult? And now we're going to ask doctors to consider something else. Now we're going to ask them to say, what could happen to me? Could I be sued? Am I going to have to pay? And we have to be clear, OBGYNs already have the highest malpractice insurance in the country. So first of all, what is it going to do to their rates? I mean, even if they don't fear, even if they're confident that they can give emergent care to somebody who needs it, are they going to be able to afford the insurance to continue to practice in the state? These are the things we also need to think about. Yes, we need to think about the emotional and passionate discussions we just had because they are important. In fact, for me, they're front and center because, as I said, my daughter is always front and center. But we also have to think about the medical landscape that we are creating in this state and how we are making it so difficult for our doctors. And we don't need to, because there's already a mechanism in place for somebody who is pregnant to get compensation in the impact or in the case of if she was to lose a pregnancy. So I don't understand why this is even needed in the first place. And so I want us to be thoughtful when we are voting. I want you to think about your constituents. I want you to think about your constituent who is pregnant and is hemorrhaging and is losing that pregnancy and needs a doctor to save their lives. And I want you to think about if there will be a doctor there to help them. And if you have a child, if you have a daughter or a best friend who has a child, I want you to think about that person. Think about that when you press up or down. Think about the lack of health care in this state already and vote on that, because that is what we should be thinking about right now, giving people more access to health care, not restricting it.
Representative Gant.
Thank you, Mr. Speaker. I yield the floor to Representative Tant.
Representative Tant.
Thank you, Mr. Speaker. I'm going to tell a story that is pretty much the soundtrack of my life. My mother was 20 and my dad 24 when they found out very joyfully they were pregnant with what would have been, or who would have been, my sister had she lived. At 7 months gestation, my mother developed life-threatening hypertensive toxemia with her blood pressure through the roof. She was swollen. Her heart was on the cusp of failure because of overwork, and she was diagnosed with what was then called toxemia, which is now called preeclampsia. Preeclampsia, as many of us women who've had children know, is a very dangerous condition. Despite the efforts of my mother's doctor, my father was he could not get her situation under control. My father was presented with, you can't have them both. Who are you wanting to save? Do you want to save your wife? Do you want to save your baby? You can't have them both. Now, my mother wanted desperately to be a mother. My father was excited about being a dad. He described this situation to me over the course of my childhood with great anxiety, he talked about the chaos. He talked about the panic. He talked about the fear of my mother. People go through pregnancy losses at any stage in life. And by the way, if you haven't read, preeclampsia is increasing. It's up to 67% now in our country. Women are facing this regularly. Maternal and fetal death as a result of preeclampsia. People lose pregnancies at any stage of life, and during that, any pregnancy loss, which I, in fact, experienced 3 times, you're traumatized. It's very traumatic. I don't see any scenario under this which medical providers won't be targets of more lawsuits, ever. The medical director of my hospital here, when you lose a pregnancy, you're angry, you're upset, you're grieving, you're defeated. The medical director here of my hospital is an OBGYN. She tells me about the losses in her profession daily as a result of this, not just under the scenario we've discussed, but under the scenario of a badly wanted, cherished pregnancy, like my mom and dad. This is not an easy discussion. The growing shortage of OBGYNs and the lawsuits that will result of this bill will, in fact, have a chilling effect on the medical practice that women and men who want to have babies with their wives will face. In my district, there's only 3 infant maternal health specialists for 8 counties, only 3. So women are already facing difficulty getting good care. I cannot, in good conscience, vote for this bill, and I ask for your no vote as well. Thank you.
Representative Gant.
Thank you, Mr. Speaker. I yield the floor to Representative Rayner.
Representative Rayner.
First off, before I even go into my debate, Representative Tant, thank you for sharing that deeply personal story, but you shouldn't have had to share that deeply personal story in order for folks to understand why this is a bad bill. You are going to hear from colleagues probably much more learned than me about the legal issues with this bill, but I can tell you that this bill legally is a dumpster fire. That's a legal term. I can tell you that this bill legally is asinine. It's actually insane. It makes no legal sense because the things that the bill sponsor says that he's trying to do are already found in existing law in different places. And I'm still unsure how someone can sue for an unborn child when there's no birth date and death date. A lot of it, the math isn't mathing, but that's nonetheless. What I'm gonna talk about and close out my debate in is that this bill is evidence that the state of Florida, if it is passed as it stands, cares not about women. Period, full stop. We offered amendments that a mother should be able to provide consent. Y'all said nah. We offered amendments that if a pregnancy was a result of trafficking or a result of incest or rape, that there would be no lawsuit. Y'all said no. We even asked if there was attestation of a domestic abuse, that lawsuit could not be brought by the abuser. Y'all said no. How many more ways are we going to tell women from this chamber that we do not care about them? How many more ways? Y'all have already done everything else. What more can we do? The bill sponsor has said, well, we want to make sure that folks can bring lawsuits and all of those things. Cool, great, but let's do it in a way that's thoughtful and responsible and intentional, and it is not. This bill opens lawsuits up for bad actors. We have seen it happen in Arizona. We have seen it happen in Texas. And we always think when we watch other states do things that won't happen here in the state of Florida. Guess what? It does happen here in the state of Florida. We have a cluster, you know what, with the school voucher program that we saw in Arizona. And that we told y'all was gonna happen here, and it's happening. So the logical inference would stand to reason. If that's happening in other states with similar bills, why would that not happen here? But I digress. To me, this bill passed as it is written is egregious. It is a slap in the faces of women. It is a slap in the faces of women who struggle to find bodily autonomy. And as someone who is a survivor of domestic violence, it is a slap in my face. And yes, I wasn't pregnant by my abuser, but what if I became pregnant? It is a slap in the face of women who are literally trying to make decisions for their lives. And we have men who cannot give birth to a child, a man who does not know what it is to be pregnant, a man who does not know what it is to have organs to be able to carry a child, making decisions for a woman's body. Y'all, when is enough is enough. I asked last year, do y'all want to come into my OBGYN's office? Maybe we should have a bill to do that, because that's the slippery slope that we're on. Y'all, we're tired. Come on. The people of the state of Florida are tired. The women of the state of Florida are tired. And we are asking you to vote down this bad bill. 57% of the people of the state of Florida said they don't want y'all involved in their medical care, especially when it comes to abortion. But yet y'all just do what you want to do. This is crazy. This is actually insane. And it's not funny, because this has real life complications. It's not funny. It's not. And that right there tells the people of the state of Florida what you think about them. Vote down on this bill.
Yes, ma'am. Representative Gant. Time having expired, actually. Representative Maggard.
Thank you, Mr. Speaker. I yield the floor to Representative Cassell.
Representative Cassell in debate.
Thank you, Mr. Speaker. Members, today, as a 20-year attorney, a day like today makes me proud to stand in this chamber, because today is a day that we get to close loopholes that many other states have already decided needed to be closed. We get to bring justice to people who right now do not have access to the courts. And as someone who started my career as an assistant state attorney, who fought for victims of domestic violence, who fought for victims of crimes, who didn't defend them, who brought justice to victims, today is a day that we can celebrate, because we are passing legislation that is going to provide that access to courts to people who currently don't have it. And I know it's been a little bit of a while, but the bill before this, Representative McFarland's bill, we brought justice to people who are victims of negligence by the state, by our cities, by our state, by our government. We felt that was important enough that we were going to fight for those victims to make sure they had access to the courts and to make sure they got the justice that they deserved. We didn't hear from our colleagues in the back that we had concerns about insurance there. We didn't hear from our colleagues in the back that we had concerns about doctors leaving the state of Florida. We had support for that legislation. And after this bill, we're going to hear another bill from Representative Trabolsi that's going to provide relief to victims that are currently prevented from access to the courts in a similar situation to what we're debating right now. Representative Trabolsi's bill is going to bring relief to victims who currently don't have access to the courts because of age, because they're not married, because they don't have children. And the same advocates that are in opposition to that bill are going to advocate that it's going to bring up insurance costs, that doctors are going to leave the state. So what's different about this bill? Why is the next bill going to pass with colleagues in the back row voting yes and not this one? Because the definition of who the victim is in this case makes them uncomfortable. It is still a victim. We are talking about mothers who wanted children. We are talking about families who planned for the arrival of that child. And because of no fault of their own, that child is no longer with us. I am a mother to the most beautiful 10-year-old little boy. And we are in one state out of 43 other states, blue and red, recognize this cause of action. As a mother, had I lost that boy because of somebody else's fault, I would have been really mad in the state of Florida had I not been able to seek justice for him. That's what we're doing here today. This bill explicitly says causes of actions cannot be brought against mothers for seeking lawful medical care. The sponsor said on the record, you can travel out of state to seek health care if you need to. This is not about abortion. And too often, when we talk about a pregnant woman, it always goes to the side of the mother that didn't want the child. But what about the mother who wants one? What about the mother and the family who wanted that baby? That's what this bill does. Don't make it anything more. This bill provides a cause of action that 43 other states recognize, that say if you, as a mother, lose a child because of somebody else's negligence, you have access to the courts. And I believe in our justice system. It is the best justice system in the country. And they have all the avenues available and necessary to make sure frivolous and meritless lawsuits get kicked out of court. So if somebody brings a cause of action that caused harm to that mom, guess what? It's going to get kicked out of court. But don't stop this bill from passing because now all of a sudden you don't trust the justice system. It's the best one we have in this world. Members, this bill does not empower men. It recognizes mothers. It recognizes their loss, their pain, and their right to accountability. Justice should not depend on whether you like the definition of who the victim is. I ask for your favorable support.
Representative Maggard.
Thank you, Mr. Speaker. I yield the floor to Representative Oliver.
Representative Oliver on debate.
Thank you, Mr. Speaker. Members, I have wanted to be a mother as long as I can remember. I always dreamed of having just a full, messy, loud, crazy house like the one that I got to grow up in. Like so many women, I had a really difficult journey in getting to that point. I can't explain to you the amount of heartbreak and sorrow and disappointment and just feeling of utter hopelessness that my husband and I went through on our journey to become parents. I wouldn't wish it on my worst enemy. But when I finally did manage to become and stay pregnant, I've never felt such incredible gratitude. The joy and the apprehension when we got that pregnancy test back, the look on my parents' faces when they found out they would finally get to be grandparents, the way that my brothers turned into absolute puddles at the idea of becoming uncles. Those first little flutter kicks that happen right around 15 weeks that just feel like butterflies. The way that my daughter would start doing somersaults whenever I would eat ice cream, which was all the time. So we got a lot of somersaults. Just singing to my babies, reading to my babies, talking to them throughout the night. That was just some of the most special times, special moments of my entire life. Now, I've heard the debate about this good bill today, and members, I think we've lost the thread. This bill recognizes what every single one of us knows to be true, that an unborn child has value, that the parents who lose that baby due to the negligence of somebody else, they've suffered an irreplaceable loss. Loving parents who are on their way to the hospital to deliver their baby, who are struck by somebody who runs a red light, and they lose that baby, they can recover damages for the property that was damaged, but not for the life that was taken. They can recover for the car seat that was in that car, but not for the baby who never got to sit in it. It's not right, and it's not just, and I hope, members, that we can correct this wrong today and that you will join me in supporting this very good bill.
Representative Maggard.
Thank you, Mr. Speaker. I yield the rest of the time in this segment.
Representative Gant.
Thank you, Mr. Speaker. I yield the floor to Representative Escamani.
Representative Escamani.
Thank you, Mr. Speaker. Thank you, Representative Gant. I first just want to provide some clarity. Under current Florida law, if a pregnant woman suffers an injury resulting in the loss of her pregnancy, she can bring a civil lawsuit for damages against the wrongdoer to recover for the loss of her pregnancy. And we have case law that help to affirm and confirm that point. I don't think anyone in this body disagrees with the powerful testimony that was shared when it comes to the loss of a pregnancy and the trauma around that. And of course, if there is negligence, the access to the courts to seek justice. And I want to make sure that we provide that clarity. And I do thank our colleagues for sharing such beautiful testimony, because I know how sensitive this topic is. As someone who has not become a parent yet, but wishes perhaps to become one in the future, I empathize with everyone's testimony. But I do want to uplift that the concerns that many of us here have in the Democratic caucus are reflective of the concerns of 57% of Floridians who are exhausted by this body's efforts to continuously chip away at basic access to reproductive care that may not fit what your preferences or your ideology is or your value system, but nonetheless is the freedom of Floridians to make a decision about their life and about their future with their doctor, their God, their family, not us as politicians. And the way that this bill is written today, it absolutely broadens the scope, and it opens up a path for litigation, not even litigation, as we talked about, to directly target everyday women and those who care for them, but of course, litigation that would continue to chip away at was once a right to privacy in our state when it came to reproductive access to care, and now, of course, has been diminished to a near total abortion ban, with aspirations in this body and next door and at the Florida State Supreme Court to eliminate it completely. And we can't ignore that. We can't ignore that. This bill does not address a gap in law. In deep contrast, it opens the door. It opens the door for civil lawsuits against doctors, hospitals, friends, and even family members who help someone access care that they need. It's a dangerous bill, regardless of how you try to paint it or the questions that are pivoted away from. At the end of the day, We don't have to speculate about what happens next because we've seen it in other states. And there are not 42, 43 states that pass this. At most, there's probably 8. So I'm not sure where that analysis came from, but I'd love to see it because I'm very curious. And so I have to ask, right, who does this help? Because it doesn't help families. It doesn't help women. It doesn't help victims of abuse. And it's not helping Floridians who send us here to make their life better, to champion economic policies to address the affordability crisis. But it does send a clear message that this legislature continues to be more interested in punishing, policing, litigating people's private medical decisions, especially those of women, versus supporting them in their times of need. And so I ask all of us to vote no on this bill, and I thank Mr. Speaker for the opportunity to share.
Representative Gant.
Thank you, Mr. Speaker. I am going to speak about some objective points that are gaps in this bill. And you know, I appreciate being here in the back row and having the ability to have nuance with how I debate and vote on bills. So the first objective point that I'll make is that when we're talking about the probate process, right, you have to submit a death certificate. In the state of Florida, every single death certificate has to have a date of birth, it has to have a date of death, and it also has to have a social security number because that is how you identify a decedent. So when I asked you about, will the parents have to apply for a social security number, and you said that's a federal agency, the federal agency mandating or regulating social security numbers has nothing to do with the requirements of the state of Florida are for a death certificate, 1, and 2, what the requirements are to open a probate, okay? So this bill does not address any of that. It does not give any guidance. It does nothing to address how are we actually going to establish the death and birth of this decedent, because you are calling the fetus a decedent, right? In order for a personal representative to be appointed. So that objectively is an issue in the process of a wrongful death suit, which requires a probate. And I know this because I practice probate, okay? Now, my next thing is regarding the PR appointment. Yes, in the state of Florida, a person convicted of a felony offense cannot be appointed as personal representative, but that does not prevent a person who has a pending criminal case from petitioning as appointment. It also does not prevent a person who has not been reported. For us to stand here and act like everyone who suffers sexual assault actually reports it is very, it's weird, honestly, because we know the Me Too movement swept across this nation, and the Me Too movement wasn't comprised of fairy tales and lullabies. It was comprised of women and men who have been sexually assaulted and have not had the courage over years and years to report their assault, right? Because we can look at the situation with the Epstein files and how we have literal victims saying what happened to them in the Epstein files, still not even getting justice right now. So the notion of thinking that everyone reports their rape and their assault and has it documented with police reports and everything, that is, 1, a fairy tale, and 2, it does not relinquish the fact that they've been raped, and this person who raped them does have an avenue in this bill. There's also language in their bill that says blood relative. So say, for instance, right, we don't allow the rapist. So he's a convicted felon. Well, what about his mother acting on his behalf as his durable power of attorney? And a durable power of attorney in the state of Florida can initiate legal proceedings. That's a blood relative. Is that permissible under your bill? And I would posit that it is based on the reading of the bill. My next thing is when we're talking about a rapist, rapists in the state of Florida's parental rights have to be affirmatively terminated. They're not automatically terminated as a parent, their rights as a parent, just because they get convicted of rape. So if they do decide to have someone to advocate on their behalf as their agent, in fact, through a durable power of attorney, that person can proceed forward with legal proceedings under your bill. So these are not just like situations where it's, we don't want to talk in hypotheticals. These are actually avenues based in statute and law. And this is what we've been saying. And just because we're in a back row doesn't mean that our ideas aren't good ideas and good policy, okay? So with that, I am going to go ahead and yield to Rep. Bartleman for debate.
Rep. Bartleman.
Thank you, Mr. Speaker. A lot of times when this chamber brings bills, they're bills that mirror or duplicates of bills in other states. This bill has been passed in Texas, Arizona, and Alabama. In Texas, we saw frivolous lawsuits. In Arizona, we saw an abuser able to sue an abortion clinic even though he drove his ex-wife to the clinic. And in Alabama, we saw the shutdown of the IVF industry. That's a really big deal. Now, we sit up here and tell you these things, but it falls on deaf ears. For example, I sat here when we discussed vouchers, and I told everyone in Arizona, they're using the homeschool money to go on ski trips. Not a year later did we find out that in Florida, they're using their voucher money for Disney passes. So when we bring up our points, we're making them because these bills have already been tested, and we're trying to fix the loopholes and the pitfalls. Now, a point was made that the back of the room voted for a sovereign immunity bill. That wasn't about court access. That was simply about raising caps. That doesn't have anything to do with access. It has to do with caps. Number two, it's being framed to the public that a mother and a father cannot sue. That's what it said. A mother needs to recoup her damages. She lost her child. I've lost a child. You all know that. And I believe that they are entitled to collect on those damages. And to say that this bill now allows that to happen, I want to point out that currently under Florida law, and I'm going to give you the court cases for the attorneys in the room. Tanner versus Hartog in 1997 says that if a pregnant woman suffers injury resulting in the loss of a pregnancy against the wrongdoer, she is entitled to damages. The mother can already sue. Don't sell this to the public that this allows the mother to sue. In Cameron versus Hurley, Florida District Court 2000, it actually allows each parent to sue and recover $2.5 million in damages for their pain and suffering due to the negligence of a third party. This is already in law. So that begs the question, why are we here and why do we need this bill? What are the true intentions of the bill? Now, I'm not going to speculate, but people out there are speculating as to what the intentions are. Most importantly, what this bill does is it allows people to file lawsuits without the mother's consent. And because that language was not added to this bill, we filed very important amendments. We filed an amendment to have the mother consent to the lawsuit. That would have solved everything. Rape, incest, abusers, stealthing, solved everything if the mother had to consent to the lawsuit. Number two, that was rejected. The second was about allowing rapists and people who commit incest and human traffickers to sue. That was rejected. Number three, we saw another lawsuit that says that if you are an abuser, you're not allowed to sue. That was rejected. Why? Why are you doing this to pregnant women? It makes me crazy. Now, I want to talk about the other things. This bill opens up a new door. It allows for civil lawsuits for damages against a friend or family member of a pregnant person who drives them to a clinic, who drives them to the hospital. I want you to go back and face the mother of a daughter who has been date raped, and now she's getting sued by the guy because she drove her daughter to the clinic. Or the mother of a 14-year-old who's impregnated, and now the 15-year-old father is suing that mother. Just think about that. What is going to be your response to them? In the worst moment of their lives, they're going to be allowed to get sued. What else does it do? It allows for civil lawsuits for private businesses, state and local governments, and homeowners for up to 2 years after a miscarriage happens. And these are not lawsuits by the mother, because the mother can always do this. These are lawsuits from a party that the mother does not consent to. It also financially incentivizes anyone who impregnates someone else, including abusers, rapists, ex-partners, and casual partners. Private industry needs to really pay attention to this bill. The mother already has access to all of this. What is this really doing? There are going to be unintended consequences. There are going to be suits against doctors who treat women for something other than a pregnancy, for a broken wrist, for a stubbed toe in an urgent care facility. And then the boyfriend, 2 years later, brings forward a suit because of that pregnancy resulting in a miscarry. And the point I want to bring out that's most important that nobody talks about is you keep saying it's a lawful act will be protected. Correct, but a lawful act will only be determined in a court of law. What does that mean? That mother of that teenage girl, she has to go out and hire an attorney. That mother of that teenage girl has to get a second mortgage to defend herself. That hospital, that doctor, that nurse, their liability insurance is going to go through the roof. And you know what? It doesn't matter. We speak to the insurance industry. It doesn't matter if you win or lose the suit. It's the cost in bringing the suit forward. We already have an insurance crisis in the state. We talk about liability insurance. We talk about medical malpractice insurance. This opens Pandora's box. Mothers already have the ability to do this. Why are we expanding this? And I would say it's for reasons that I definitely disagree with. But I don't want to argue those reasons because everyone has a different opinion. But I can tell you that everyone in this chamber wants to make sure that businesses can flourish, that victims aren't re-traumatized, that we don't create an insurance crisis in other industries, and that's exactly what this bill is about to do. I urge all of you to vote no on this bill. This bill is not needed. Lawsuits can already be brought forward for damages. And again, this is opening Pandora's box for the state of Florida. Thank you, Mr. Speaker.
Representative Maggard in debate.
Thank you, Mr. Speaker. I yield the floor to Representative Redondo.
Representative Redondo.
Thank you, Mr. Speaker. Members, you may recall we heard this bill last session, and I had the opportunity to debate in favor of the bill, and I'm honored to be able to do so again today. And for those of you who know me, I'm not really the loud, the yelling guy. I'm kind of more the quiet guy, but I feel like on this issue in particular, as someone who practices in this area every single day, who currently is representing the victims of those who have lost loved ones today, who has had to tell mothers, fathers, parents, there's nothing we can do. The law doesn't allow you to recover. This is particularly important to me. And because I'm a lawyer and there were some points raised, I do want to address some of these things just from the practical standpoint, again, of someone who does this. First, to be clear, currently, since 1978, at least in the state of Florida, you cannot recover for the death of an unborn child. Full stop, period. Okay? What you can do is you can recover for your own injuries. So for example, if a mother's involved in a car accident, she herself is injured, and she loses her unborn child, she can of course still recover for her injuries, fractures, cost of medical care, emotional distress. Neither parent can recover anything for the death of their unborn child. That is the status of the law. That's not up for debate. That's a fact. So this is not something that is already addressed. This is actually a real problem that exists today. I also want to talk about some of these issues with respect to things like surrogacy. As the sponsors already pointed out, surrogacy, when we're talking about the mother, it's very clear. There's absolutely no exceptions for any kind of lawsuit brought against the mother. But even in cases of gestational surrogacy, our statutes already require that the surrogate mother consent to reasonable medical advice and treatment. Okay? And it also already states expressly that only the surrogate mother is responsible for medical decisions during the course of a surrogacy. So there's already protections in place for gestational surrogacy. And we also heard about things like other states, Texas, Arizona, et cetera. Well, first, I'd remind everyone we're representatives here in the state of Florida, but I actually happen to be licensed in the state of Texas too. And I can tell you that the key difference, which you've heard about already, is that here in Florida, our process is somewhat unique. In Texas, which I've represented families who've lost loved ones in Texas as well, every single survivor can bring their own action. Mom, dad, siblings, etc., when there's a wrongful death. In Florida, that is not the case. The same is true in Arizona. Okay? What we have is a special process that provides protection. So all of the examples we've heard about friends, about mothers driving their daughters, etc. Folks, I mean, I know we've got other lawyers in the room. I would ask you to find me a single lawyer who will bring a claim like that. Again, this is all I do. I don't know a single person who would bring a claim like that. But even if you could find someone, because you could say, well, Mike, there's going to be somebody who's willing to do it to, quote, make a buck. Okay. Well, we have probate judges across the state that are the gatekeepers. And I can tell you right now, having opened probates on behalf of wrongful death victims myself, representing families in those cases, I've never had a probate case where a personal representative was appointed without unanimous consent from the survivors. So in a real-life case, if mom comes in and says, I don't want a part of this lawsuit, period, the probate judge is going to say, well, why not? If it's because the person who's seeking to become the personal representative is an abuser, is a rapist, is a sex trafficker, I can assure you, folks, that person will never be appointed as a personal representative in this state. And I can also assure you, if that were to ever happen, there are legal remedies to protect people, okay? We've heard things about, well, lawsuits can be filed and it subjects people to unnecessary distress. That's true, but that's just, we don't have any protection. We could put in here that only viable claims can be brought. It doesn't matter. Whatever we put into the statute would still have to be addressed in the courts. Representative Cassell said it. I agree. This is the best justice system I've ever seen, the best in the world. It's imperfect, right? Yes, are frivolous claims brought? They can be. But we do have processes in place to handle those when they're brought. And everything I've heard so far has been talking about sort of the exception to the rule. What about if a rapist brings a claim? What about a sex trafficker? Folks, I think we're forgetting that this is an example of the exception swallowing the rule. Let me give you two hypotheticals, two mothers, both looking forward to the birth of their unborn child on the way to the hospital. One of them gets into a car accident at 8 a.m. before their child is born. The second gets into an accident at 8 p.m. after their child is born, but on the way home. Under current Florida law, that first mother cannot recover anything, period, full stop, for the death of their unborn child. Doesn't matter if it was a drunk driver, doesn't matter if somebody purposely ran into her, tried to hurt her, hit her in the stomach with a baseball bat, nothing. That same mother, driving home 8 p.m. after the birth of her child, would be entitled to recover. That's all we're talking about. The rest of the examples, again, there are processes in place that will protect both the mother, the father where appropriate, and everyone else. We're not going to have this flood of vexatious litigation. It's just not going to happen. I used the same term last session. It's the parade of horribles. That's what we say in law school when it's like, well, I don't have a great way to attack the merits, so I'm just going to come up with a bunch of hypotheticals that maybe would come true. I'm telling you now it won't come true. But what will happen today, and what has happened in our state, is parents are being denied the right to recover for the death of their unborn children. And this bill will fix that. I think we're going to find that in this next bill, we're going to have another class of people who are currently unable to recover, and I would ask for consistency. You'll see me vote up on this great bill now, and I encourage you to do the same.
Representative Maggard.
Thank you, Mr. Speaker. We yield the rest of our time back into Tyler.
Thank you. The remainder of debate time having been yielded, Representative Greco, you're recognized to close on your bill.
Thank you, Mr. Speaker. Colleagues, thank you for your thoughts and for this conversation. This bill will allow grieving parents to recover in the tragic circumstances in which they wrongfully lose their unborn child. We've heard a lot of conversation today about hypotheticals, about abusers. I will tell you, members, this bill cannot be used by an abuser against the mother. But who this bill can be used by is a mother who, at the hands of her abuser's abuse, loses her unborn child. She can use this bill to seek justice against her abuser. This bill is for the mother who driving home from work, 6 months pregnant, gets slammed by a drunk driver, and right now cannot recover for the wrongful death of that unborn child. That is who this bill is for. There is perhaps no worse occasion in life than when parents lose their children, born or unborn. This bill seeks, as best as courts and dollars ever could, to allow those parents in that horrible, life-altering, worst moment they could imagine to have the opportunity to have their day in court, to seek justice. Members, think about those parents. Think about those mothers. Think about those horrible moments that right now we have a gap in our system, that we do not have an opportunity for justice, to be made whole. That is who this bill is for. Members, I'd ask your support, and I'd ask that we take this step to give parents the power and the ability to seek to be made whole in the worst moments of their lives. Thank you for your support.
The question now occurs on final passage of CS for HB 289. The clerk will unlock the machine and members will proceed to vote. Have all members voted? Have all members voted? The clerk will lock the machine and announce the vote.
76 yeas, 34 nays, Mr. Speaker.
Show the bill passes. Read the next bill.
By Representative Shabolsi and Representative Lopez J. and others, House Bill 6003, a bill to be entitled An Act Relating to Recovery of Damages for Medical Negligence Resulting in Death.
Representative Shabolsi, you are recognized.
Thank you, Madam Speaker. This bill aims to repeal Florida Statute 768.21, which takes away the ability for family members to recover non-economical damages if their loved one is over the age of 25, unmarried, and with no dependents. And that is the bill.
Are there questions of the sponsor? Seeing no questions of the sponsor, do we have any debate? Representative Chambliss in debate. Got to back it up a little bit. Are there amendments on the desk?
None on the desk, Madam Speaker.
Should the bill rolled over for third reading? Representative Shabolsi, you're recognized to make a motion.
Thank you, Madam Speaker. I'm a little rusty here. I apologize. I move that the rules be waived and HB 6003 be read a third time by title and placed on final passage.
Representative Shabolsi moving to waive the rules. The bill be read a third time by title. Let's read the bill a third time. All those in favor say yay. Yay. All those in favor? All those opposed say nay. Show the bill rolled over for third reading. Read the bill a third time.
By Representative Shabolsi and Representative Lopez J. and others, House Bill 6003, a bill to be entitled An Act Relating to Recovery of Damages for Medical Negligence Resulting in Death.
Is there debate on the bill? Representative Chambliss in debate.
Thank you, Madam Chairwoman. Wanted to highlight one of the families from Miami-Dade County that during our delegation meeting came and testified in support of this bill. Wanted to highlight their experience if I could. Mr. Ed Salazar is a member of Miami-Dade County, a resident of Miami-Dade County from the Florida Medical Rights Association. In 2009, his son Christopher was in a very serious auto accident. For 18 days, he showed steady improvement, and on the 19th day, unfortunately, Christopher died of cardiopulmonary arrest. You see, Mr. Salazar is a registered respiratory therapist with more than 50 years of experience, and Christopher's mother is a critical care registered nurse. In other words, they're experts in this field, and they thought that their son died as a result of medical error. You see, Mr. Salazar is also the author of the 2014 book, A Free Kill, and it documents every element that the family went through for this horrific event. And so when he came and he spoke in support of this bill at our day delegation, I was touched, and I have been in contact with that family, and they are watching now. And with this vote, we will be taking an important step in righting the wrong that has happened to this family. With this bill, we are one step closer to providing justice for Christopher. Thank you.
Any further debate? Representative Henson in debate.
Thank you, Madam Speaker. The first year in the legislature, I got to witness this bill from the other side. A parent who lost a child over 24. This law addresses them as well. And after that, and I supported, absolutely, actually, Representative Spencer Roach, former representative who was pushing that bill. Then comes one of my own constituents whose father died, and she's over 24 from being, he died, he didn't have to die. They knew what was wrong with him. They just didn't take care of it. They ignored the patient, and he died. Sabrina Soche, I do want to give her credit. I filed this bill the first year. Of course, you guys didn't hear it, but thanks, Trabulsi, for sponsoring this bill. She built a real support and advocacy. She spent time with all you legislators on both sides of the aisle, building a system of support for this bill. I want to give her credit for that. And I do want to say this is a good move. I appreciate you guys for doing this. This was my constituent that built this, this revolution, and I hope you all support it today.
Any further debate? Representative Lopez J in debate.
Thank you, Madam Chair. This bill is about real people, like Keith Davis, Leonor Cardenas, Geraldine Creighton, Jojo Thompson, Deborah Lickenscomb, Derek Crocker, Lynn McGill, Steve Aguilar, Taylor Jenkins, Maria Severino, Cameron Perit, Sadie de la Cruz, Stefan Suro, and Heather. Their stories remind us that the language in our legal code has real consequences, and it is our responsibility to ensure that Florida's laws reflect the principles of justice, fairness, and opportunity that define our great state. House Bill 6003 is about making history in the state of Florida. No family should be denied justice simply because their loved one was unmarried or without young children at the time of their passing. Florida is the only state with this restriction, and it is time for that to change. This bill also protects some of our most vulnerable citizens, our elderly, widows, veterans, people with disabilities, adult single individuals, and the good doctors who serve them. It ensures that the law is fair and does not unjustly restrict the rights and opportunities of those who have worked hard, sacrificed, and contributed to our communities. This is about our constituents, the people of the Great Sunshine State who deserve fairness and justice. Representative Trabulsi, I deeply appreciate your leadership, partnership, and commitment to ensuring Florida remains a state that champions freedom and opportunity for all. I also want to thank Speaker Perez for believing in this effort. Members, each vote is very important. It sends a direct message that we are representing our constituents across the state of Florida. I also want to thank Sabrina Davis and the many constituents who have shared their personal stories throughout the years, stories of parents and children who have been impacted by laws that should have been updated long ago. Let's come together to support this bill, remove outdated language from our statutes, and continue making Florida a leader in freedom, fairness, and good governance. I respectfully ask for your support on House Bill 6003. Thank you so much.
Seeing no further debate, Representative Trabulsi, you're recognized to close.
Thank you, Madam Chair, and thank you, Representative Lopez. You've been a wonderful prime co-sponsor, and it is just a pleasure to work across the aisle with you on this important piece of legislation. And I appreciate you mentioning all of the people that we have become friends with and their family members that lost their lives due to medical malpractice, some of which are in the East Gallery with us today. And sadly, I'd like to say I am, running this legislation for you, but I'm not, because you have nothing to gain from this. Your loved ones are already gone. This bill will not affect you or your families whatsoever. And I think it's important when you see almost 20 people in the gallery today here, so that what happened to their families will not happen to your families. It's just that important. They take time out of their day, they take time away from work, away from school, and they relive what they have been through and the suffering, knowing that not only will they not get to spend another birthday or holiday with their loved one, but that there will be no recourse for them. So thank you all for showing up for this important bill. In 1990, this piece of legislation was passed, and we've talked a lot about insurance today. This bill was passed to lower medical malpractice insurance. And guess what? It didn't lower medical malpractice insurance. And a few years later, another bill was passed that states that doctors do not even have to carry medical malpractice insurance. And that was passed to lower the rates. And guess what? The rates weren't lowered. Now, I believe in Florida that we have world-class health care. I believe we have some of the best physicians in the United States and quite possibly the world. Our healthcare system is fantastic. And there are bad outcomes. And bad outcomes don't necessarily mean medical malpractice. But there is medical malpractice. And when there is, we should be able to hold someone accountable. And we can in every other section of law except this one. Unless you have a loved one that is over the age of 25, unmarried, and no dependents. And in that scenario, your family members just don't count in the state of Florida. And that is wrong. Representative Redondo and Greco talked about if a drunk driver slammed into a mother who was pregnant and that the mother's child passed away, what the recourse could or could not be. If someone slammed into your loved one with a car, the recourse would be that they would have the ability to access the courts for non-economical damages. With this law, the law that we are trying to repeal, that's not available. Representative Salzman, this is an un-American law, right? Constitutionally, in America, we deserve access to the courts. There should be no exceptions to that. And that includes if you are over the age of 25, unmarried, and with no dependents. There are a couple of myths out there. All of you know that this bill made it all the way through the House and the Senate and to the governor's desk last year. And it was vetoed. And some of the reasons that it was vetoed is because it doesn't have caps on it. Well, this has gone through the courts, and caps have been deemed unconstitutional. That's why there are no caps on this bill. Also, it was said that we will have family members coming out of the woodwork to sue. We will have multiple family members, and there will be nuclear verdicts multiple times for one victim. That's just not true. An estate has to be formed. An estate is who brings forth the case, not individual family members. So it's just not true. This is an unjust law. This is our opportunity to make it right. I appreciate, again, all the folks who come to support, and I am sorry for the loss of your loved ones, but I so appreciate your friendship, your phone calls, your support, knowing that you were trying to make the lives better for future victims of medical malpractice. And members, I ask for your support.
The question now recurs on final passage of HB 6003. The clerk will unlock the machine and the members will proceed to vote. Have all members voted? Have all members voted? The clerk will lock the machine and announce the vote.
88 yeas, 17 nays, Madam Speaker.
Show the bill passes. Read the next bill.
By Representative Soroy and others, House Bill 133, a bill to be entitled an act relating to minimum age for firearm purchase or transfer.
Representative Soroy, you are recognized to explain the bill.
Thank you very much, Madam Speaker. House Bill 133 lowers the legal age to purchase rifles and long guns from 21 to 18. The legislation seeks to restore the constitutional rights of law-abiding citizens. That is the bill.
Questions of the sponsor? Rep. Young, you're recognized.
Thank you, Mr. Speaker. I'm interested to know kind of what has changed between 2018 when Florida raised the firearm purchase age after the Parkland shooting and today that justifies kind of reversing this policy.
Representative Soroy.
Thank you very much, Mr. Speaker. Thank you, Representative Young, and welcome to the chamber. Congratulations to you, sir. I wasn't a member of the legislature when this policy was enacted. In my view, it's the wrong public policy for Florida to pursue. I've offered this legislation now a number of years, and you see it once again today.
Representative Young.
Thank you, Mr. Speaker. Representative, did you know that a recent poll shows that about 80% of Florida voters oppose lowering the firearm purchase of to the age of 18?
Representative Soroy.
Thank you, Mr. Speaker. Thank you, Representative. My legislation isn't driven by polling.
Representative Young.
And so who supports this bill?
Representative Soroy.
Thank you very much, Mr. Speaker. Thank you, Representative Young, for the question. You know, I think that the answer really is a worldview. I am someone who believes firmly in our Constitution, firmly in our Second Amendment. Legislation that I have offered throughout the course of my time here has always erred on the side of law-abiding citizens, law-abiding people, small business owners, and families. I view this legislation as the correct public policy for the state and offer it as a way for families and individuals to keep themselves safe by restoring the rights of 18-year-olds to buy long guns.
Representative Young.
And so would you say that our colleagues who preceded us in this body didn't take that into consideration in 2018?
Representative Soroy.
Thank you very much, Mr. Speaker. Thank you, Representative Young, for the question. You know, first of all, there is no joy in this. There is no joy in this. I was not a member of the legislation when this bill was pursued the first time, when those solutions were sought. At the time, I firmly believed that the legislature, you know, arrived at the conclusion as best they could with the information that they had available. It was a tragedy what happened, and the legislature responded at the time the way that they thought best. As I said, I was not a member of this body. Had I been, I would not have voted for that bill based on some of the reasons that I've described here and in committee previously and over the last few years. There is no one to hold accountable for that. I have a different view in terms of the policy that we should be pursuing, and I offer that for the body's consideration today.
Representative Robinson F.
Thank you, Mr. Speaker. And I was listening to the response, and my question has to do with what you said about safety. Being an educator, we talk about young people and their brain's development, and it talks a lot about usually your brain is not fully developed until probably about the age of 20. So I guess my question comes in, you talked about safety. Would it be safe for 18-year-olds where studies show that their brains are not necessarily completely developed to be buying long guns that we know tend to be the guns that are used in our school shootings?
Representative Soroy.
Thank you very much, Mr. Speaker. Thank you, Representative, for that question. Good afternoon to you. You know, in our law and in our custom, we convey rights and responsibilities to 18-year-olds, serving on a jury, in many cases running for office, being eligible for military service. That is when our citizens come into the ownership and privilege that they have of being citizens under our Constitution. As I've said before, I believe that our ability or the right of 18-year-olds and over to exercise this right was infringed upon by the legislation that was passed previously. I acknowledge that freedom and security cause friction between one another. They always have. I understand your point of view, and I hear you. But again, I believe in the constitutional right as it exists, and believe that at 18 you acquire the right to be able to defend yourself and your family from harm. Now, that's not to say that I don't believe that criminals should be held accountable. You know, we have criminals in our country. We have people that will ignore the laws. We have people that will defy every measure of safety that we try to enact. This legislation is more in recognition of the folks that are law-abiding citizens that do exercise their rights freely and responsibly. That is who this legislation is focused to.
Representative Antone.
All right, thank you, Mr. Speaker. I guess a simple question. I don't necessarily know the law. But if an 18-year-old, if this bill passes and an 18-year-old is able to purchase a gun, can they then take that gun onto a college campus and keep it in their dorm room?
Representative Soroy.
Under current law, no.
Representative Antone.
Thanks again, Mr. Speaker. And just for clarification, so if the bill passes, can they then take the gun that they have purchased and keep it in their dorm room?
Representative Soroy.
Thank you very much, Mr. Speaker. Thank you, Representative Antone, for the question. I'm not aware of that changing any policy that's in place regarding campus carry.
Representative Henson.
Thank you, Mr. Speaker. Representative, are you aware that 18-year-olds are still on high school campuses?
Representative Soroy.
Good afternoon, Representative Henson. Thank you for the question. Yes, ma'am, I am.
Representative Henson.
Don't you believe that this would give high school students that are 18-year-olds an easier access to get guns on high school campuses?
Representative Soroy.
Thank you, Representative Henson, for the point that you're trying to make. I believe that law-abiding citizens will follow the law and that criminals will break the law because they are criminals.
Representative Henson.
I appreciate you understanding what I'm trying to imply, but we are talking about criminals. Mass shooters are criminals. This will give them easier access to get a gun on a school ground.
Representative Soroy.
Thank you, Representative Henson. One of the good things that I think have come from the Marjorie Stoneman Douglas legislation is that we've hardened our schools and we've put in place programs like the Guardian program that allow individuals that are trained to be able to respond to these kinds of attacks against soft targets, in essence. The other thing that we've done is this legislature, year after year, has provided dollars for the hardening of our schools and school security. So while I have disagreement over this specific policy, I don't disagree with many of the elements of that legislation as it relates to school safety.
Further questions of the sponsor? Representative Escamani.
Thank you, Mr. Speaker, and I apologize. I had to step out in the beginning. So if it was repeated, please just let me know, Chair. I guess I'm curious, when it comes to currently law enforcement and military who are under the age of 21, they go through extensive training, psychological review, and so forth. Obviously, in this case, that would not be required. Maybe just walk me through why not require some basic training of firearm safety if we are going to reduce the age back to 18?
Representative Soroy.
Thank you very much, Mr. Speaker. Thank you, Representative, for the question. I'm not going to walk you through it. I'm simply going to say that I believe it's the correct public policy to pursue for the state of Florida, and that under our Constitution, law-abiding citizens have a right to keep and bear arms.
Representative Escamani.
Thank you, Mr. Speaker. Thank you, Chair. Has there been any public health impact analysis on the potential harm with increasing this access and reducing back to 18? For example, I'm thinking about accidental shootings, unfortunate circumstances involving suicide, those types of dynamics.
Representative Soroy.
Thank you, Mr. Speaker. Thank you for the question. None that I'm aware.
Representative Escamani.
Thank you so much, Mr. Speaker. And you might have already answered this because I heard you speak to this point about the balance between safety and rights and so forth. But I'm curious, do you have any research to say that your proposal makes us more safe, makes Florida more safe?
Representative Soroy.
Thank you very much, Mr. Speaker. I believe that law-abiding citizens have a right to defend themselves and their property. That's the only study that I need to be aware of.
Representative Escamani for the last question.
Thank you. I don't think that was a study, but I understand, Chair. Okay, well, just to wrap up my last question, is it true that allowing teenagers to buy firearms increases the risk of school shootings and other violent incidents?
Representative Soroy.
Thank you very much, Mr. Speaker. Representative Escamani, let me clarify my last answer. The study I referred to is the Constitution of the United States. The second point that I would make, no, I'm not aware of any study related to the material that you cite.
Are there amendments?
On the desk, Mr. Speaker.
Read the First Amendment.
Representative Bartleman offered the following amendment with title amendment, barcode 299653. Remove lines 14 through 16 and insert an amendment.
Representative Bartleman, you're recognized to explain your amendment.
Thank you. Hold on. Thank you, sir. Hold on. I just want to make sure I have the right amendment. This is barcode 2. Okay, so this is changing the 21-year-old. Okay. That is the right barcode amendment, right? This amendment is very simple. It just simply raises the age to purchase a long gun back to 21. So it's kind of undoing what the representative is undoing. Now, every year we debate this bill, and I have to say the sponsor is always so sensitive to how painful this is, and I appreciate that more than anything, by the way. And every year we have to come back and bring up these points. This bill is the gold seal bill that other states look at. We responded to a horrible tragedy. Representative Hanschowski, Representative Daley, and we represented that community as a mayor, as a commissioner, and as a school board member. Everyone, and a lot of people in this chamber actually walked through that building, which is frozen. It's frozen. Just balloons on the floor, food on the table, drinks, backpacks, and you see the harm that was done. The reason why the age of 21 is so important is because the science is clear. Adolescent brains are still developing. The frontal lobe actually may not fully develop to 25. Why is the frontal lobe so important? That's where executive functioning develops. The brain's management system responsible for impulse control and weighing consequences. Okay? That's why we move that. And not only that, the Supreme Court, there's case law for death penalty for crimes committed by people that are under 21. And they use the science of the frontal lobe for that case law. So it's not unheard of. It's not silly science. And it's important. Also, the statistics are clear. 18 to 21-year-olds commit gun homicides triple the rate of adults 21 years and older. Also, this bill was very thoughtful.
Representative Bartleman, you're just presenting your amendment at this point. You'll have a chance to close, so that the time to present has expired, so we're going to move on. Questions on the amendment? Are there questions on the amendment? Are there amendments to the amendment?
None on the desk, Mr. Speaker.
Is there a substitute amendment?
None on the desk, Mr. Speaker.
Is there debate on the amendment? Representative Robinson F. in debate.
Thank you, Mr. Speaker. And I just want to take a moment to thank Representative Boderman for this particular amendment. This actually is what I was trying to address with my questioning. As she stated about the studies, we know that our young people's mind is not fully developed. And when we talk about safety, I think it kind of even goes back to what we did a couple of sessions ago when we talked about social media. We're protecting our kids. I just don't understand why we would not continue to protect them when it comes to gun violence. Time and time again, not only in the state of Florida, but across our nation, we continuously have gun violence. And most of the time, it is with young people that are below the age of 18. So I just want to thank Representative Boderman for bringing this particular amendment. I think this is a good amendment. We should not rush back into changing this law. Please take the facts. We talk about data all the time, and if people are doing these studies, then I think we should actually take heed to that. And I would like to also make reference when it was saying that, talking about law-abiding citizens, one of the things that I would definitely say is that when we think about age, voting is not violent. Having a gun is. So there's a difference, and we should actually acknowledge that and make sure that we keep our people safe. So thank you.
Further debate. Representative Hunchofsky.
Thank you, Mr. Speaker. Representative Bartleman, I just want to thank you for this amendment and your recognition that the Marjorie Stoneman Douglas High School Public Safety Act that passed in 2018 was the gold standard, and that every element in that bill is the reason, and every element in that law we have today is the reason that our schools are safer today than they were prior to February 14th, 2018.
Further debate. Representative Bartleman, you're recognized to close on your amendment.
Thank you, Mr. Speaker, and I apologize. This is emotional for all of us who were there and part of the healing and seeing the suffering of the families. I'm going to go back to the science and the statistics, but then I want to talk about what this does to the families. I told you already the science is clear. The adolescent brain is not developed to 25. I've told you that 18 to 21-year-olds nationally commit gun homicides at triple the rate of adults at 21. I also want to talk about how thoughtful this was. This was a bipartisan bill, and it was passed in this chamber, and it was so thoughtful that we recognize that members of the military and members of law enforcement should be entitled to have a gun because they're trained. So there was a carve-out for them. I also want to point out some of the issues here with this bill now with the new open carry that's happening in our state, and that we got rid of licensing for concealed carry permits. We have no rules really in the state when it comes to guns, and that's by design because there are people who feel that way. We don't require a permit. We don't require training to own a gun. We don't require safe gun storage. And now we let everyone open carry. So literally, these 18 to 21-year-olds who are not fully developed, who are not thinking rationally, who cannot think about consequences of the actions, actually can lawfully carry their AR-15 on their back and walk around. That's a dangerous situation. Also, if you watch the trial of MSD, the murderer's mother actually called the store that he was going to purchase the gun at and said, please do not give this kid the gun. And the gun owner said, I have no choice. That is the law. She begged him not to let that kid buy the gun. And subsequently, we knew what happened. But also what really upsets me about this bill is that we bring it forward every year. There is no companion in the Senate. And every year, the parents, the wife, the family members of those victims have to relive their experience. It's very cruel. Every year, I saw the Hoyers here during committee week coming to talk to some of the members. I know that Gina's dad is probably in the gallery somewhere. Why do we keep doing this to them? Why? Why do we keep, if there's not a companion, if you know it's not going to move, it's the sheer pain you're causing these families by bringing it again and again and again. I am asking you to go back to the age of 21. As Gina's dad reminds me, this bill was signed in the blood of the victims of this tragedy, and to undo it is a sin in my book. So please support this amendment, and let's, again, have the gold standard in common sense gun legislation. Thank you very much.
All those in favor of the amendment say yay. All those opposed, no. Show the amendment is not adopted. Read the next amendment.
Representative Hinson offered the following amendment, barcode 293615. Remove lines 14 through 16 and insert an amendment.
Representative Hinson, if you'll hold on for just a second, I want to give Representative Edmonds the opportunity to make a recognition of somebody very important.
Thank you, Mr. Chair. Members, if I can get your attention and your help, I would truly appreciate it. They say with every great man, behind them is an even greater woman, and that cannot be further from the truth. With me, who drove 6.5 hours to be here with me, and she's my rock, my supporter. If we get out on session on time, we'll be married. So members, if you all stand and please recognize my fiance in the West Gallery, please.
Welcome to the Florida House. Representative Hinson, you're recognized to explain your amendment.
Boy, did that change everything. Congratulations, Rep. Edmonds and your future bride. And a soror. Happy Founders Day. Okay, back to business. Got to figure out where the heck I was. So my amendment removes lines 14 through 16 and inserts, a person younger than 20 years of age may not purchase a firearm. The sale or transfer of a firearm to a person younger than 20 years of age may not be made. Mr. Speaker, that is my amendment.
Questions of the sponsor? Representative Andrade.
Thank you very much, Mr. Speaker. Representative Hinson, would you vote for the underlying bill if your amendment is accepted?
Representative Hinson.
Yes.
Further questions of the sponsor? Are there amendments to the amendment?
None on the desk, Mr. Speaker.
Is there a substitute amendment?
None on the desk, Mr. Speaker.
Is there debate? Debate on the amendment. Representative Hinson, you're recognized to close on your amendment.
Thank you, Mr. Speaker. Question, Rep. Andrade, if my amendment passes, will you vote on it?
You're closing.
Oh, thank you very much. Thank you very much. As you've been hearing from my colleagues, brain development is still a work in progress. The parts of the brain responsible for impulse control, risk assessment, and long-term consequences are still developing well into the mid-20s. They just can't delay their emotional responses. That doesn't mean 18-year-olds are irresponsible, but statistically, they're more likely to act on emotion under stress, which matters a lot when lethal force is involved. There are higher rates of violence and suicide in that age group. Data consistently shows that 18 to 20-year-olds have higher rates of violent crime and suicide compared to people 21 and up. Firearms turn bad moments into permanent outcomes. Waiting until at least 20 reduces that risk window, especially for impulsive self-harm, which often occurs during short emotional outbursts. Consistent with other high-risk age groups, we already accept restrictions for things that are far less permanent. Alcohol, you got to be 21. Handguns in many states, you got to be 21. Rental cars, you got to be 25. The logic is the same. Greater access comes with greater responsibility, and society routinely delays that access. School safety concerns are most, I did ask you about being able to bring a gun on campus at 18 because high school seniors are many 18. Lowering the age at least to 20 increases the chance that students not fully separated from school environments have legal access to firearms, which complicates prevention and enforcement. Hence, 18-year-olds can more easily end up with a gun in school. In fact, they have. This isn't about demonizing teens.
Representative Hinson, I need you to wrap it up. Your time to close has expired.
Okay, I will. Okay, so this is about high-risk exposure, at least keeping them in the 20s, not the teens, and making them have a little bit more judgment before giving them a deadly weapon. Thank you, Mr. Speaker, for the extra time.
Yes, ma'am. All those in favor of the amendment say yay. Yay. All those opposed say no. No. Show the amendment not adopted. Read the next amendment.
Representative Young offered the following amendment with title amendment, bar code 666985. Remove lines 14 through 24 and insert an amendment.
Representative Young, you're recognized to explain your amendment.
Thank you, Mr. Speaker. This is a straightforward and common sense amendment that protects Floridians. What this amendment does is simple. It creates a 7-day cooling off period for people under the age of 21 before they can receive delivery of a gun. In practice, that means a young person can still buy a firearm, but they cannot get it within their hands immediately. That 1 week can indeed be the difference between an impulsive decision and a life saved. We know that teenagers and young adults, as we have heard several times now, tend to be more impulsive and more likely to take risk. And the part of the brain responsible for judgment and long-term planning and impulse control do not fully mature until the mid-20s. I think I'm in a good place to be able to say that is so. At the same time, this bill allows more teenagers whose brains aren't yet fully developed to get more access to guns. A cooling off period is not a radical idea. Florida already uses waiting periods as a safety measure for firearms. This is just a good amendment that makes us a little bit safer. With that, that is the amendment, Mr. Speaker.
Questions of the sponsor, Representative Andrade.
Thank you very much, Mr. Speaker. Representative, I noticed that in addition to the cooling off period, you also reincorporated the exemptions for police officers, prison guards, and service members. Is that correct?
Representative Young.
Thank you, Mr. Speaker. Yes.
Representative Andrade.
Thank you very much. Representative, are you aware that service members can begin serving the military at the age of 17?
Representative Young.
Absolutely, and this isn't directed towards them because these individuals already receive formal training, supervision, and accountability.
Representative Andrade.
Thank you very much, Mr. Speaker. So, Representative, just to confirm, you are comfortable with some 17-year-olds purchasing firearms?
Representative Young.
If they are in the military, this is for private citizens, not military.
Further questions of the sponsor? Are there amendments to the amendment?
None on the desk, Mr. Speaker.
Is there a substitute amendment?
None on the desk, Mr. Speaker.
Is there debate? Representative Bartleman in debate.
Thank you, Mr. Speaker. I am so happy to have Representative Young join our team because this amendment is fantastic. We have debated this bill for 5 years now, and no one had thought of this angle. So if you think about the story I told about the murderer wanting to get the gun, he wanted to get the gun because he wanted to kill people. He was like in an episode, he was angry, and a lot of people want guns to kill people, and if you put in this cooling off period, they would have time to reflect, maybe calm down. The mother could have possibly gotten to him and calmed him down. There's so many reasons for this. It just really makes a lot of sense to do this. And I know that one of the reasons everyone says, well, you know, the 18 to 20-year-olds should have their rifle. That will be in debate. I've heard it before. The young single mother who's 19 and needs a rifle to protect herself. She's going to be okay waiting 5 days to get that rifle, like if that's her home security system. This just stops those people who really want to do harm and who are acting erratically. So I applaud this amendment. I think it's amazing, and I hope everyone will support it.
For the first time in debate, Representative Hart Lohman. Congratulations.
Thank you, Mr. Speaker. Representative, I just want to say that I think that this is an excellent amendment. You know, we've heard this bill year after year since I've been here. I am a senior. I am leaving. I have to remind you all, why do we keep bringing it back? What's wrong with being 20 or 21 to actually have these long guns? Last year, it was about, well, they should be able to hunt with them. What are we hunting? Are we hunting people? Because that's what's happening with our long guns. Very seldom in our school shootings or in mass shootings are anybody using small handguns. So I just have a problem with that, and I'm grateful that the representative has taken it upon himself. He's a young man. He knows what it's like to just be barely 20. Probably one of the youngest reps we have here. So I thank you for this amendment because we have got to think about what we're doing. You know, I understand, I heard the rep when he said that, well, you know, I'm about the Constitution. We're all about the Constitution. But at the same time, are we not about people that we're serving? When the families ask and they're happy to have the age raised, thank you so much for bringing this amendment. I hope that we have enough common sense finally to put this to rest and stop doing this to these families that have to keep coming up here year after year to hear these things. So thank you, Representative.
Representative Harris.
Thank you so much, Mr. Speaker. Representative Young, first of all, so excited to be able to say that. Thank you so much for bringing this amendment. I think a lot of what we try to do in this body as part of the minority party is to bring our perspective and take a bill and try to make it better, try to make sure that our constituents who bring concerns to us, their concerns are addressed, and try to bring common sense to the conversation. And I really do think this is a common sense amendment. It's not denying somebody between the ages of 18 and 21 the ability to purchase a gun. It's just merely asking for a waiting period. And I think that is really sensible. So I really do encourage people to vote up on this. And I thank you, Representative Young, for bringing a very good, smart, and sensible amendment.
Representative Escamani.
Thank you, Mr. Speaker. I just want to echo all the points, but also what we haven't talked about is suicide prevention. And I want to just take a moment to acknowledge that the wait period can save lives when someone is in a deep place of depression and turns towards a firearm. And unfortunately, the rates among young men have been substantially high. The waiting period, it cools you off and it delays someone harming themselves. I know we're talking about harming others, but I want to just emphasize that waiting period requirements can help save someone's life from them hurting themselves. Thank you, Mr. Speaker.
Representative Hunchofsky.
Thank you, Mr. Speaker. Representative Young, I want to thank you for this amendment that recognizes that safety and security are all about layers. And this is just adding one more layer of protection to make sure that our students and our communities remain safe.
Representative Young, you're recognized to close.
Thank you, Mr. Speaker. There's an African proverb that says, "The child who is not embraced by the village will burn it down to feel its warmth." If that proverb teaches us anything, is that when we fail to protect, guide, and place guardrails around young people, the consequences don't fall on them alone. It falls on the entire community. Voting yes on this amendment is simple, and it should be simple, because if this body is prepared to lower the age to purchase a gun, then at minimum we should also take the responsibility to protect them from themselves. Science tells us what we already know to be true. Young people are more impulsive, their brains are still developing, and their capacity for judgment and self-regulation is not yet complete. Yet this body is choosing to expand access to deadly weapons for more young people, fully aware of what is at stake. We did not raise the age to purchase a firearm by accident. We did it because children were killed, because families were shattered, and communities across Florida demanded that we act. That tragedy forced this body to confront a hard truth, that access without guardrails costs lives. To now erase those protections is not progress, it's amnesia. And amnesia in the face of loss is dangerous. Waiting periods work. We know that because Florida already uses them. A 3-day waiting period creates a cooling off moment, and a 7-day will make sure that we protect when emotions run high and when irreversible decisions are more likely. A gun can end a life in seconds, and that is why guardrails matter. That is why responsibility matters, and that is why ignoring the developmental reality of young people is not policy disagreement, it is a willful negligence. Let me be clear. This amendment does not take a single gun away from a law-abiding adult. It does not eliminate rights. What it does is simple. It just ensures that we are providing safeguards to a population we know is at higher risk for impulsive decision making. Our colleague from the 78th District said, we pass laws that have real impact. And so the question before us is not complicated. If we believe in responsibility, if we believe in public safety, if we believe that lives of Florida's children and teenagers are worth more than political talking points, then the choice is clear. This amendment asks us to slow down, not strip rights, to protect life, not score points, to remember why we acted in the first place. So I urge every member in this body to vote yes on this amendment and show Floridians that when lives are on the line, this body chooses responsibility over recklessness and memory over amnesia. With that, I close. Thank you, Mr. Speaker.
All those in favor of the amendment say yea. Yay. Those opposed, no. Show the amendment is not adopted. Read the next amendment.
Representative Hunchofsky offered the following amendment with title amendment, barcode 576851, between lines 24 and 25, insert an amendment.
Representative Soroy, for what purpose do you rise?
To make a point of order, Mr. Speaker.
State the point.
Mr. Speaker, I believe the amendment substantially expands the scope of the bill and is not germane pursuant to Rule 12.8.
Representative Garrison, are you prepared to make a recommendation on the point of order?
Thank you, Mr. Speaker. I am prepared. HB 133 specifically and narrowly addresses only the minimum age required for firearm purchases or transfers. The amendment, in contrast, establishes training requirements for all firearm purchases and transfers, regardless of age. This is both a broad and general provision attempting to amend a specific provision and would substantially expand the scope of the bill. And therefore, pursuant to Rule 12.8, it is not germane. I recommend the point is well taken.
Based on the recommendation of the Rules Chair, the point of order is well taken and the amendment is not germane. Read the next amendment.
Representative Bartleman offered the following strike-all amendment with title amendment, barcode 054103. Remove everything after the enacting clause and insert an amendment.
Representative Bartleman, you're recognized to explain your amendment.
Thank you, Mr. Speaker. I'll be short. This amendment simply gives me an opportunity to put in common gun sense legislation and close the gun show loophole. Thank you very much.
Questions of the sponsor? Are there amendments to the amendment?
None on the desk, Mr. Speaker.
Is there a substitute amendment?
None on the desk, Mr. Speaker.
Is there debate? Representative Bartleman, you're recognized to close on your amendment.
Thank you, Mr. Speaker. I want to point out that this is always about Amendment 2 rights and that there's never a gray. It's either this way or that way. But there are common sense things we can do, like oppose this current bill and support this current amendment just to say that we're trying to do common sense gun legislation. The gun show loophole is very dangerous. First of all, it allows criminals and people who are prohibited from having guns to be able to get guns. They get to buy their guns from an unlicensed seller, and now this 18-year-old can go to a gun show and just pick up a gun. And I think that's a really, really bad idea. So I hope that you will support this amendment. I wish this Marjory Stoneman Douglas Act was common sense gun legislation. This provision I'm bringing forward is again common sense. I think there is a place where we can meet in the middle, and I hope that you will support my amendment. Thank you.
All those in favor of the amendment say yay. Those opposed say no. Show the amendment is not adopted. Read the next amendment.
None on the desk, Mr. Speaker.
Show the bill rolled over for third reading. Representative Soroy, you're recognized for a motion.
Thank you, Mr. Speaker. I move that the rules be waived and House Bill 133 be read a third time by title and placed on final passage.
Representative Soroy moves that the rules be waived and that House Bill 133 be read a third time by title and placed on final passage. All in favor say yay. Opposed, no. Show the motion adopted. Read the bill a third time by title.
By Representative Soroy and others, House Bill 133, a bill to be entitled an act relating to minimum age for firearm purchase or transfer.
Are there any amendments?
None on the desk, Mr. Speaker.
Members, we're going into structured debate on House Bill 133. Debate will be limited to 40 minutes per side in 10-minute increments. Total debate time not to exceed 80 minutes. Representative Gottlieb, you are recognized to begin in debate, and the clerk will start the debate clock.
Thank you, Mr. Speaker. I yield the floor to Representative Harris.
Representative Harris, you're recognized.
Thank you so much, Mr. Speaker. When the vote took place for the Marjorie Stoneman Douglas Act, I was so incredibly proud to see people from both sides come together to do what was in the best interest of the people of Florida. It was a time when I was really incredibly proud. So imagine how disheartened I am that we are discussing rolling this back again. And having been here now for my fourth term, I've also seen this bill every single session. We lowered the age because of a tragedy that we knew could be prevented if the age was increased. Since then, there has been an alarming pattern of shootings that have happened by people in that age group: Uvalde, Buffalo, and at FSU. Last year at FSU, it happened. Gun homicide rate for youth is incredibly high, despite them being a smaller percentage of the population. We have to be careful, and we have to make sure that we're keeping safety in mind. And I agree with Representative Bartleman, that it doesn't have to be all or nothing. You know, we can preserve rights and still be really sensible and do what's right for Floridians. And I think that we did what was right for Floridians years ago when we passed that law. And I think that we should continue by not repealing it. Thank you.
Representative Gottlieb.
Thank you, Mr. Speaker. I yield the floor to Representative Hinson.
Representative Hinson. In debate.
Thank you, Mr. Speaker. I've already explained to you about the judgment issues, the impulsivity issues, as well as they can bring guns on campus. I sure hope you're paying attention. I sure hope you're paying attention. In 2018, following the Parkland tragedy, where a 19-year-old, not quite 20, legally purchased an AR-15 and killed 17 people, Florida lawmakers from both parties, and I sure hope you're paying attention. Yeah, I'm still a principal. I still hope you're paying attention. Where both parties acted responsibly and raised the minimum age to purchase rifles and long guns to 21. That law was designed to save lives, and it has done exactly that. I sure hope you're paying attention. Research consistently shows that 18 to 20-year-olds commit gun homicides at rates far higher than older adults. And the neuroscience confirms that impulse control and judgment are still developing well into the early 20s. 20s, 20-year-olds. This same age group also faces elevated risks of suicide, and access to firearms dramatically increases the likelihood that a suicide attempt will be fatal. I sure hope you're paying attention. Rolling back this law would once again place lethal weapons into the hands of teenagers at their most vulnerable developmental stage. Floridians understand this risk. Why don't you? Nearly 80% of voters oppose weakening the minimum age law, and survivors have made it clear that this protection is not symbolic. It is life-saving. We are equally alarmed by this bill, which proposes expanding Florida's Guardian program to college and university campuses. I sure hope you're paying attention. Allowing armed faculty, staff, and students to carry firearms in academic settings, high school or college, imposes a great risk to the lives of our children, our college students, and adults. That is my debate.
Representative Gottlieb.
Thank you, Mr. Speaker. I yield the floor to Representative Young.
Representative Young.
Thank you, Mr. Speaker. Members, I rise today in opposition of this bill, and I want to be very clear from the outset because clarity matters in moments like this. I believe in the constitutional right to bear arms. I am a gun owner. I believe in lawful gun ownership, and I believe that responsible gun ownership has never offended anyone. What I do not believe in is this body pretending that history does not exist. What I do not believe in is this body is selective memory when the consequences are inconvenient. A month from today, on February 14th, 2018, lives were taken in Parkland. Children did not go home that day. Families were forever changed, and in the aftermath of that tragedy, this very body acted, not out of politics, not out of pressure, but out of responsibility. This body made a deliberate decision to raise the minimum age to purchase a firearm to 21. They did not do that casually. They did it because the evidence was clear and the moment demanded action. And the people of this state expected us to put public safety above ideology. Not just a few short years later, we are being asked to undo the decision as if it never mattered. Members, this is not leadership. This is retreat. This bill lowers the age requirement not because something has improved, not because conditions are safer, and not because the risk has disappeared, but because priorities have shifted. And I'm deeply concerned about what that shift says to the communities we represent. Science has not changed. Brain development has not changed. Impulsivity in young people has not changed. Access to firearms in moments of crisis has not become less dangerous. So what has changed is our willingness to look away. We cannot keep telling families that their pain justified action then, but not now. We cannot say safety mattered in 2018, but convenience matters in 2026, and we cannot claim to honor victims while dismantling the very safeguards their loss compelled us to create. Dr. Martin Luther King Jr., which I think is apropos as we are headed into this weekend, warned us that we are not makers of history, we are made by history. And the history of this body on this issue is clear. We acted once because there was loss. We acted once because safety mattered more than politics. We acted once because doing nothing was unacceptable. And this bill asks us to unlearn that lesson. It asks us to pretend that the reasoning we relied on then was flawed, that the risk we acknowledged then no longer exists, and that the lives we sought to protect then are somehow less worthy of protection now. That is not progress, that is erasure. And I don't know about you, but I cannot support legislation that requires us to forget our own history, abandon our own judgment, and gamble with the lives of our people. Leadership is not about convenience, it is about courage. And courage demands that when we do better, when we know better, we do better. For those reasons, and with respect to this body, I ask all of you to vote no on this bill. Thank you, Mr. Speaker.
Representative Gottlieb.
Thank you, Mr. Speaker. Members, I just want to address the body for the remaining time in this segment and say that as a father, as a gun owner, as a criminal defense lawyer who works in the system and works intimately with youth, I see the harms of this bill. I'm very familiar with the Supreme Court cases that we've already heard about, and the science that we've talked about the maturity of these young minds. And what I love about the law as it exists today is that somebody can gift a gun. So somebody can gift a gun to their 18-year-old child, because that parent can make the decision that their child has reached the age of maturity or has that familial training, has hunted with their father or mother over the years. But what we're doing here is we're allowing an 18-year-old who maybe hasn't mentally reached that age. And that was the harm that the Marjorie Stoneman Douglas Commission found, was in that very case, the murderer went and bought a gun despite the objections and protestations of his parents. And that's the harm that we seek to protect. And that's why we're urging you not to lower the age. Thank you.
Representative Maggard, you're recognized in debate.
Thank you, Mr. Speaker. I recognize Representative Black at Representative Smith's desk.
Representative Black at Representative Smith's desk, you're recognized.
Mr. Speaker, and Happy New Year, members. We're off to a spirited start. You know, I've heard much today about the development of young men and women too, I suppose, their prefrontal cortex, the development of judgment. The irony, though, is not lost on me that this comes from the same caucus that believes that not 21-year-olds, not 20-year-olds or 18-year-olds, but even 12-year-olds are mature enough to cut off their body parts. But I digress. The irony, though, leaves me almost speechless, but fear not, I am never actually speechless. You know, we're in a structured debate. Members, I think on these polarized issues that we have in our time, we could actually do with less debate. And look, coming from me, I love a good debate. But when you debate, there's a winner, there's a loser, and sometimes we're just trying to win the debate. I'd really like to see in our society us have a little less debate and a little more honest discussion. And so although this is debate, I want you to know that it comes from a spirit of discussion. I want to tell you a Christmas story. You ready for a Christmas story? It was 45 years ago, Christmas morning. I bounced out of my bedroom to the Christmas tree, and I was so excited. At age 5, I had gotten my first BB gun, and I had become lethal to tin cans with that thing. And at age 10, I had gotten a single-shot Harrington and Richards 20-gauge single-shot shotgun. And with that, I was able to tag along with the men and bring food home for the table. But what I really wanted was a 12-gauge pump. And with that, I'd be able to hunt larger game, and soon I would be allowed under the law to go hunt by myself. It was a rite of passage. And I just wondered, when I went to that Christmas tree, was I going to get it? I went through all the square boxes, really frustrated, and I didn't see the shape that I was really looking for. And I was sad. I didn't see what I wanted. And Mom said, sort of with a smirk, "Hey, son, did you look behind the Christmas tree?" No, I didn't look behind the Christmas tree. And I looked, and my dad chuckled. And there was a long, narrow box. And I opened it up very carefully, very safely, because I knew. And there it was, that shiny Sears and Roebuck 12-gauge pump shotgun. I still have it today. And with that, I had crossed a rite of passage And you know what I did? Oh, well, as soon as school got back in, I took it to school, like all the boys did back then. We could have our guns in our cars. The guys that had pickup trucks had gun racks in the back, and you could see their new shiny firearms. We had a security guard on our campus. Now, you better not take it out of the car, but Mark was his name. We called him Mark the Narc, and he'd get in the car with you and look at your new gun. We would be so excited. We'd be going hunting after school or going plinking. But you know what we didn't think about? We did not even think about shooting our classmates. The thought never entered anyone's head. It didn't happen. It didn't happen because our parents taught us right from wrong. We didn't want to go to prison. We didn't want to be executed. We didn't want to go to hell. I graduated high school. I took that gun with me to college. I had a scholarship. It didn't pay for a lot. My parents were working class. They did the best they could, but there were times it was tough to put food on the table. And I would go hunting to supplement the grocery budget. I was grateful for that. Even today in rural counties throughout Florida, young men, 18, 20, 21, and women too, more than you might think, use these firearms to feed their families at a time of greatly increased costs, at a time when we know affordability is a big issue. We've made it harder for them to provide for their family, and not just provide for their family, but protect their family. And not just protect their family from the criminal element. We've talked about that enough. Look, out where I live, way back in the woods, there are things that just need a bullet. There are things that must be shot. Whether it be a rabid coyote or a fox in the hen house or a rattlesnake on the porch, we need our guns. They are useful tools. We use them with regularity. And it has been that way from time immemorial. My family have been here for more than 8 generations. When we came over in 1803, the Spanish ruled, and this was one wild place, and all of the males bore arms. Not only did you bear arms, and by the way, I don't mean 18 to 21-year-olds, boys, what we would call boys today, were bearing arms because they had to. They even carried them with them to school. They, unlike in later years when I went to school, carried them into the classroom and leaned them up against the wall because they feared Indian attacks. And also, when they were walking home, they were afraid of rabid wolf attacks. They were afraid of bears and panthers. And they might see a rabbit that they could bring home to mom for dinner. And you know what has been absent from nearly 5 centuries of young men and women bearing arms, even in the schools? School shootings. That is a relatively recent phenomenon in our culture. Only about 26 years ago did that become a feature of our culture. Now I ask you, that Sears and Roebuck shotgun that I still have today, and all the other firearms out there, did they change? Did that inanimate object somehow become sentient? Did it somehow start speaking to us? You know the troubling answer to that question, don't you? That's why I want to have this in a spirit of discussion, because the truth is horrifying. Members, it's not the guns. This is a red herring, a huge distraction that distracts us from acknowledging a terrifying truth. There's something in us that has changed. It's not the guns. There's something in the lives of our boys, of our men. And by the way, they're almost always, when we're talking about mass shooters, boys and young men. They're finding this throughout our studies. They go back and they study past school shootings, beginning with Columbine, and they're trying to find purpose in their meaningless lives. And as long as we think that we have a simple solution, that it's gun control somehow, when it wasn't for most of 5 centuries, we pursue a false solution, a red herring. See, we could be having discussions about what the breakdown of the 2-person family has done to young men and boys in our society. We could talk about fatherlessness. We could talk about the loss of faith. We could talk about things that really might get us somewhere. But we have this distraction. And history, over centuries, teaches us that that's not the answer. Because it didn't happen back then. Yet it happens today. Let us not take away people's right to feed their family, to protect their family. Let us instead agree with one another from both parties that we will go forth this day and seek real solutions to real problems. Members, I invite you with me to go hunting right now.
Thank you, Rep. Black.
Let us hunt the great red herring. Push your button, vote for, and that will put us on the path to save lives. Thank you, Mr. Speaker.
Rep. Gottlieb, you recognize.
Thank you, Mr. Speaker. I yield the floor to Representative Antone.
Representative Antone.
All right, thank you, Mr. Speaker. Let me start out by saying I'm going to have an honest debate about 18-year-olds being able to buy guns. The Columbine shooters, which set this whole thing off some years ago, they bought their guns in a private transaction, and they were under the age of 21. Last year, I told you the story about me with a Winchester rifle shooting at a person that went to my school. Now, I shot near him. I didn't shoot at him because I don't want to go to jail, and I want nobody to come back and prosecute me. But I will tell you, had my dad not pulled up in that parking lot and started honking that horn while I was shooting near him, there's a good chance I would have shot that guy. So, what I want to say here today is oftentimes this legislative body, not necessarily this year, but every year, doesn't learn its lessons. Last year during session, April 17th, I think, a 20-year-old kid at Florida State University had his mother's guns, and he killed 2 people on campus and injured some others. The Marjorie Stoneman Douglas shooting, the guy that killed 17 people there and injured 18, he bought his gun on the first day of his 18th birthday. Now, what this bill does, if I read it correct, is it conflicts with federal law. It only allows an 18-year-old to buy a gun through a private transaction. There are people that show up in my district that sell guns out the back of their cars, out the back of their SUVs. They show up every 2 weeks, once a month. And so now if this bill passes, an 18-year-old could legally purchase a gun in that private transaction from the back of a car or from the back of an SUV. There are kids that go to high school now, underage kids, 15, 16, 17, 18. They already own guns. They hide the gun down the street just in case they need that car. So I'm going to just close out by saying this. I just don't think it's a good idea for us to allow people under the age of 21 to buy guns, whether it's a private transaction or from a licensed firearm dealer. It's just not a good idea because in Florida, we have evidence the deadliest high school shooting in the country took place in South Florida, and it was a 19-year-old. And then last year, a 20-year-old at Florida State shot up the campus at Florida State. Thank you.
Representative Gottlieb.
Thank you, Mr. Speaker. I yield the floor to Representative Escamani.
Representative Escamani.
Thank you, Mr. Speaker. Members, our responsibility at the bare minimum is the safety of our state. And you have already heard the data from both our questions and from my colleagues' debate points around this legislation not leading to a more safe state. In fact, opening up the ability for 18, 19, 20-year-olds, which is what this state did in the past, which created the pathway for someone to legally purchase a firearm and murder children, is why this body in a bipartisan fashion came together to say enough is enough. And yes, we have the Second Amendment, but the Second Amendment can exist with safety as an aspect for there to be thoughtful and measured regulations. And so I urge you to think about the past few years, how we have loosened other gun rules in this state and how dangerous this mixture is, not just for the health and safety of all of our children, but also the health and safety of that young person as well, and their ability to make a decision that may not only harm others, but also harm themselves. And so for those reasons and more, I urge each one of us vote no on this bill. Communities like mine, Orlando, have also experienced the trauma of mass shootings. All of us have at this point. And so let's do our best to prevent it from happening, not loosen laws that make a bad situation worse. Thank you, Mr. Speaker.
Representative Gottlieb.
Thank you, Mr. Speaker. I yield the floor to Representative Daly.
Representative Daly.
Thank you, Mr. Speaker. Members, 296 days. 296 days. Less than a year ago, we sat in this same room, on this same floor of this same chamber, with this same piece of legislation under a different bill number. Like Yogi Berra said, it's deja vu all over again. And just like that day, I stood on this floor and asked what has changed, because members, nothing has changed since the Marjory Stoneman Douglas Public Safety Act was passed in a bipartisan fashion all those years ago. Now, last year, well, it's not even a year, 296 days ago, I mentioned a number of arguments. I'm not going to go into all of those again. Members, I won't mention that most school shooters are 18 to 21 with a long gun. I won't mention it. I won't mention the fact that we all know the brain isn't fully developed in that same age range. I won't mention that this bill contains no sort of training or other requirements before that 18-year-old can go and purchase, but I know that some in this room like to talk about those who are willing to step up and serve in the military, and God bless them. But the difference is that individual who stepped up to serve has undergone a background check, has undergone a mental health screen, has undergone, at least in the case of the Army, a 6-week intensive marksmanship course, for the first 3 weeks of which they're not even touching a firearm. So you want to talk about that, then we can have a conversation about lowering that age, but that's never the conversation in this room. I won't mention that the Marjory Stoneman Douglas Act that was passed was overwhelmingly bipartisan and voted on by members who were here at the time who now serve this state in various capacities, not the least of which is the United States Senate, the United States Congress, the Florida Senate, and some former and current presiding officers of this very chamber. I won't mention that nothing has changed, members, but the political environment clearly has. I won't mention that, again, this year, there's no Senate companion, the only saving grace year after year. And I won't mention that I'm a gun owner myself and a former prosecutor. I'm not coming for anybody's guns. I just think we need to be a little bit more reasonable, a little bit more responsible with them. What I will mention is why we did it. And you heard Representative Bartleman, Representative Gottlieb, and others mention it a little bit. The shooter in the case of my alma mater was a 19-year-old with a long gun. And that background that Rep. Bartleman shared. His mom didn't want him to have that firearm. But there was legally nothing that stopped him. So he walked in, purchased it, bought an AR-15, killed 17 and wounded 17 more in my alma mater in a matter of minutes. As you may recall, I was there that day, within about 30 minutes of the shooting. I, as well as Representative Bartleman, Representative Hunchofsky, and some others, have had the opportunity to spend some time with the families, hearing their child's hopes and dreams, hearing what they were like before their life tragically ended. And it hasn't stopped with MSD. Just yesterday, I spoke to a mother and a father whose 17-year-old was killed a few weeks ago in my district. He had access to a loaded firearm. Now, I'm going to be clear, it wasn't a long gun, but hear me out, because the significance is the same. This individual was working in a retail store in my district. He had access to a safe that included a loaded firearm. This 17-year-old, who's just months, by the way, away from being able to walk in and purchase a long gun if this were to pass, took that loaded gun and started to show off for his friend. Started to show off for his friend, held the gun up, cleared the cylinder, held it up, shot it, nothing came out. Said, "See, the gun is safe." Then he put it to his head in a Russian roulette style and pulled the trigger and unintentionally blew his own brains out. That's the same age, couple months difference, that we are open to allowing, if this was to pass, that individual to walk in and buy an even more powerful, even more dangerous firearm. And you know what his parents asked me for? They didn't want to ban guns. They weren't trying to take them away. They asked for training. They asked for us to change the standards as to safe storage to include situations like his. And I had to tell them, folks, it's not going to happen, not in this legislature, because we're too busy debating bills like this. Members, I hope you never have to have the conversations that me and other members of this chamber have had with our constituents. Vote no.
Representative Maggard.
Thank you, Mr. Speaker. We yield our time back in this segment.
Thank you. Representative Gottlieb.
Thank you, Mr. Speaker. I yield the floor to Representative Bartleman.
Representative Bartleman.
Marie, you're next.
Thank you, Mr. Speaker. 17 people are dead because someone under 21 whose mother would never in a million years would buy him a gun and tried very hard to make sure he couldn't get one, including, as mentioned, begging the store clerk not to give it to him. Bought a gun, went into MSD, went into the freshman building, and killed. I was so proud of this state for creating legislation that was common sense. Like I said, it's not black or white. I am also a gun owner, which many people would be surprised about, and a concealed carry permit holder, because I had to learn about that in order to debate it a couple sessions ago. So I realize that, there is a right to have guns. People believe that, and I respect that. However, currently, we do have provisions in law for public safety. Because if the Constitution was black and white and everyone was able to get a gun, then why do we prohibit felons from getting a gun? Why do we prohibit people on probation from getting a gun? And then why do we prohibit those adjudicated dangerous, unable to have a firearm? It's because we recognize that this is not black and white. We recognize that this is about public safety. We know the data. We know that 18 to 21, they're 3 times more likely to commit a homicide with a gun. We know the science of their brain development. It's used for death penalty cases at the U.S. Supreme Court level. And it is in the best interest of public safety that we prohibit an 18 to 21-year-old from walking into a store and purchasing a gun independently. If you want to go hunting, your parent can give you that gun under your Christmas tree. But when someone is irrational, erratic, and hot-tempered and wants to do damage, the last thing you want them to be able to do is walk into that store without checking with a parent, without checking with an adult, an older adult, to see, should I be doing this? Now, we tried to bring some common sense into the bill. The waiting period is the best idea by far for me. safe gun storage is a great idea. Training is a great idea. And of course, I like my idea going back to 21. But I wish we could get where everything doesn't have to be so black and white, and we look out for the safety of our community. So I am urging you once again, as I always do, to vote down this law. We owe it to our community to keep them safe. And if you did not walk through that building, I don't know, you should have, because I don't know how you can vote for this bill after seeing that destruction. Thank you, Mr. Speaker.
Representative Gant.
Thank you, Mr. Speaker. I yield to Rep. Woodson.
Representative Woodson.
Thank you, Mr. Speaker. Members, we have passed a lot of good laws in this chamber. And one of those good laws was when we were able to increase the age from 18 to 21 where a young person can buy a gun. That was a great law. We were sending a message, but we were giving a little solace to these parents, those family members who have gone through so much by losing their loved ones. We have our own colleagues in this chamber who had to be there for some of those family members from Parkland. We know Representative Honchowski, Representative Daly, Representative Bottleman, who are dealing with the Parkland shooting. But also, we know so many other communities who have been impacted by gun violence. This is a serious business. This is not theater. This is not theater. This is a serious business that we have to deal with. I heard one of my colleagues mention that they did not want to go to hell when they were 18, so they would not shoot. Do you believe that those kids who suffer from mental health want to go to hell? Think about it for a minute. You think they want to go to hell? That's why they're shooting? I think we all know better than that in this chamber. We are seeing so many of our young people suffering from mental health, anxiety, you name it. Instead of addressing this issue, we are opening it again for 18-year-olds to be able to buy a gun. What message are we sending to those parents? What message are we sending to them? This is not an easy pill for them to swallow. How are we going to look at those parents? I am so sorry, Rep. Honchowski, because I know, as a mayor of Parkland at the time, I know what you went through. I know, because I can see it. It's been so many years. And sometimes she starts tearing just talking to some of those parents. Rep. Daly has to do with that every day, every time they're in Parkland. They live there, actually. They represent those constituents. Members, we can do better than that. FSU is in our backyard. And we saw that senseless shooting that happened at FSU. I had some students coming to my office to talk to me about this bill, and they said they cannot believe that we are bringing this bill back. Our black and brown communities, you are seeing shooting every single day. This coming Saturday, I'm going to a funeral. Rep. Robinson and myself, we're going to a funeral of a mother who lost her son as a result of gun violence. And now you know what? She also lost the daughter. Members, this is a very important issue. And it really hurts me to see some of us who are not taking it as serious as we should. When we ran for office, we made a commitment to do right by everyone. All the people of the state of Florida, no matter what political party, no matter creed, religion, whatever it is. But this issue here, we need to really think about it twice. Yes, we want to carry gun. We want to make sure this is a free state. We understand that. But understand that our young people who are dealing with so much through no fault of their own, because I even heard the parents don't raise them right. That has nothing to do with how you raise your kids who suffer from mental health. That has nothing to do with it. So members, I'm asking you one more time. Think about this piece of legislation. Think about the way that you are about to vote on this bill and spare the children and the families of the state of Florida. So I'm asking you to vote down on this bill. Thank you.
Representative Gottlieb.
Thank you, Mr. Speaker. We yield our time in this segment back.
Thank you. Representative Maggard.
Thank you, Mr. Speaker. We yield our time back in this block.
Representative Gottlieb.
Thank you, Mr. Speaker. We yield our time in this block in its entirety to Representative Hunchofsky.
Representative Hunchofsky.
Thank you, Mr. Speaker. Earlier, we heard a Christmas story, a holiday story from an individual about their childhood experience. I'd like to share with you a Valentine's Day story. On February 14th, 2018, where wives, fathers, and mothers dropped their loved ones off at school. They were all excited, wondering if they would get a chocolate or a rose, if the person they liked was there. And you know what they didn't expect? That they would be hunted and murdered in their school. They didn't expect when they went that morning, when they said goodbye, it would be the last time they ever saw them. And it didn't just make them sad, it has impacted every part of their lives and every holiday thereafter because someone is no longer there. We keep talking about the Constitution, and yet on March 14th, 2025, the 11th Circuit released an opinion on the current law holding that prohibiting a person under the age of 21 years of age from purchasing a firearm does not violate the 2nd and 14th Amendments because it is consistent with the historical tradition of firearm regulation, and because the law was enacted for the same reason that such restrictions were previously imposed, which was to stop immature and impulsive individuals from harming themselves or others with a deadly weapon. And we hear a lot about the founding fathers in this chamber. And in colonial times, people under 21 were not treated as full adults in the eyes of the law. They were considered a minor or an infant. Founders like Thomas Jefferson and John Adams made this point very clearly. Jefferson said they cannot take care of themselves, and Adams said they were not fit to be trusted by the public because of their lack of judgment. That is how our founding fathers felt about this age group. Today, we've had amendments dealing with cooling off periods, training, and none of those passed. We also know that lowering the age back to 18 is incredibly unpopular. And it doesn't mean we follow every whim of a poll, but it does mean in a representative democracy that we represent the people we serve. And we make sure that their opinions and what they believe is right is what we represent here in this chamber. I am so incredibly proud of the bipartisan members who voted for the Marjorie Stoneman Douglas Public Safety Act. It'll be now almost 8 years ago. They showed political courage and did not cower to the loud voices of a very, very small minority. They understood that there are layers to safety. And that's why in the bill, it includes mental health support. It includes school hardening. And yes, it also includes a constitutional way to make sure guns don't end up in the hands of those who wish to do harm to themselves or someone else. Because safety is in layers. If you go back to the Sandy Hook shooting, David Wheeler, whose son was killed, said, "When I look at the events that led up to the morning of Friday, December 14th, 2012, it appears to me to be like a line of dominoes. Very specific things had to happen for those dominoes to line up and to have them fall the way they did that morning. But when I look at those dominoes, all I can see are the spaces in between where someone could have stopped the next domino from falling." We heard earlier today on another bill that we had families here that wouldn't have benefited from the bill that was passing, but they wanted to make sure that what happened to their families would not happen to your families. This bill today is going to hurt families, and we have had families who lost their children, families who lost spouses from Marjory Stoneman Douglas High School come here over and over again. And they did that because they don't want anyone else to feel the pain that they not only feel every day, but they are forced to live with, and they're forced to be reminded of every time we do this over and over again. This bill has stood the test of time. It has stood constitutional challenges. There is no reason that the current law should be rolled back because it's working. When the families recently came up, and some of you may have met with them, some of you may have not, I know they were having trouble getting some meetings, which is not something they've experienced before. And they do feel like it doesn't matter anymore. One of the moms said to me, "We're just another shooting now." And I promised her that I would say that today because I don't want anyone to ever feel that they are just a number and that the lives of their loved ones didn't matter. There is no reason to roll back the current legislation. Constitutional, supported by statements from our founding fathers, and it's working. It's very hard to deal with trauma, and I get very emotional when I talk about this, but it doesn't mean the facts and the law aren't on my side. I am not willing to take a risk that anyone should have to see their loved ones after they've been murdered at school on a day that's supposed to be about love. It's hard to sometimes put in words what people are going through and this call to action that comes afterward. I was not in the legislature when the bill passed, but I was here as not only the mayor of Parkland, but a friend to many of those families, knowing them previous to the shooting. And anything that happened then was because people decided the cost of doing nothing was too high and was something they wouldn't be able to live with. I feel that going back on what was done then, the political courage that was done then, would be devastating and heartbreaking because it's so hard to find that kind of bipartisan political courage these days. I would like to close with a short part of a poem written by Amanda Gorman. It's called Hymn for the Hurting. She says, "We may not grieve, but give. May we not just ache, but act. May our signed right to bear arms never blind our sight from shared harm. May we choose our children over chaos, and may another innocent never be lost. Members, please support me in voting against this bill.
Representative Maggard.
Thank you, Mr. Speaker. I yield to Rep. Porras.
Representative Porras.
Thank you, Mr. Speaker. Members, earlier this week, I had the privilege and the honor to escort our Governor, Ron DeSantis, into this chamber, as many of you saw. And while he gave his State of the State address for the last time, we all remembered one of the main themes was protecting that Second Amendment. And one of my colleagues earlier mentioned that the Senate does not have a counterpart to this measure. And it's not something that we're new of here. Year after year after year, we have legislation like this. The leader has sponsored legislation similarly to this that has gone on deaf ears on the other side of the chamber. Now, I think that this is the Florida House of Representatives is the people's house. We are the most representative form of government to our constituents here in Florida. Now, I thought it was interesting that obviously the governor chose to shake the Senate president's hand, but not our speaker's. But it is the other chamber that is usually the objector for some of the policies that this House passes and that the governor seems to say that is the model for the rest of the country. So when we talk about our Second Amendment, I empathize with some of our colleagues, but this House does not waver when it comes to our constitutional rights. We do not buckle or yield when it comes to having adversity in this chamber. We fight for our constituents, and we fight for those rights that we hold dear. And it is times like those, when we remember those difficult moments, that our constitutional rights are more important than ever. So I ask you, colleagues, not just to press the green button today in support of our constituents, support of our gun owners, and support of our House, but do it to send the message to that chamber that the Florida House does not wait. We do not wait for next session. We do not wait for special sessions. We act today. So members, please support this great bill. Thank you so much, Mr. Speaker.
Representative Maggard.
Thank you, Mr. Speaker. We yield the rest of our time back in totality.
Debate time having expired, Representative Soroy, you're recognized to close.
Thank you very much, Mr. Speaker. I want to thank the members for the thoughtful and passionate debate today. As I said earlier, there is no joy in this. There is no joy in it. And to the families and the people that suffered a result of this monstrous act, I will not even attempt to assign words to the horror and the pain and the tragedy that occurred in Parkland. But this bill, as is presented today, presents a fundamental question. Should government diminish the rights of law-abiding people in response to criminals? Should government diminish the rights of law-abiding people in response to criminals? Nothing in this bill changes our commitment or the resources that we will dedicate to hardening our schools and school safety. As I was listening to the debate today, I have to admit I'm anxious to finish watching Ken Burns' new documentary on the Revolutionary War. If you all haven't seen it, it is fantastic. And they spend a lot of time in this series. It's like 7 one-hour episodes, maybe a little bit more than an hour, talking about tyranny and the nature of tyranny. And that there were layers involved, the colonists, the enslaved people. In one remarkable point, we defeat the Hessians in a major battle, and Washington wants to show them sympathy because the Hessians are victims of royal tyranny as well, sold by one king to be hired by another king to fight a battle that they had no stake in. That was oppressive. It piqued my interest so much, I went and looked up the definition of tyranny. And the definition cites cruel and oppressive rule. another layer of tyranny that they dealt with while the men went off to fight in these battles, or enslaved persons went to start a new homestead, or people deserted the Patriot Army and the British Army to go start their own life out in the wilderness. When the men left to go and fight these battles all over the colony, criminal bands roamed the countryside. It was something that Washington was concerned about almost as much as fighting the British, because when the men were away at these battles, when they were in Saratoga, for example, these bands would go in, rapists, thieves, and they would loot and plunder and abuse. And when the men would go and fight, they would leave a rifle behind. And the rifle was not there for amusement or fun. It was a tool for the self-defense of the homestead. And what this bill is trying to correct is an inequity that exists in the law. It is privileged to gift a firearm to a family member. But for the young mom that lives on the rough side of town by herself, she doesn't have the right to go out and buy one to defend herself and her family. That's cruel. That's tyranny. Tyranny can come in many forms: a foreign ruler, an unjust government, or a monster coming through a window in the middle of the night. All of them are cruel, and all of it is a form of tyranny. This bill restores the rights of some Floridians to defend themselves. Now, I want to be crystal clear, and I want you to hear me. This country has a problem with school shootings. This country has a problem with school shootings. But the answer to that is not to infringe upon the constitutional rights of law-abiding people. I have been paying attention, and I'm going to be frank with you. Maybe the problem is that family values in this country have consistently been under attack. Maybe the problem is that these parents aren't involved. They're not the disciplinarian. They're not the chief law enforcement officer. They're not the ones taking responsibility for their child. They'd rather be their friend. Maybe that's the problem in this country. Maybe it's the lack of hard discipline, whether it's in our schools or from the parents. Total lack of accountability for behavior. Maybe it's that our kids seek guidance from Facebook rather than the good book. Maybe it's because the 10 Commandments aren't in our classroom. Members, I don't know what the problem is, but I do know this. The answer is not to penalize. The answer is not to infringe. The answer is not to harm the law-abiding citizens of this state. When the system fails, we need to hold it accountable. And when criminals act, we need to throw the book at them. The answer is not to infringe and harm the rights of law-abiding people. There is no joy in this. There is no joy in this. I've been so impressed by Representative Young's debate today. And he quoted an African proverb earlier about fires being set to villages so children can feel the warmth of the fire. This bill is not the fire, members. The fire has been burning for a long time. The fire has been burning for a long time. And those problems that I mentioned, I don't know if any of them are contributing to this, but it's my view that it is. We have a problem in this country, but the answer is not to harm and infringe upon the rights of law-abiding people. So, to be candid, I don't know what the Senate's going to do with this bill, but I know what we're going to do with it right now. We're going to pass it. Thank you, Mr. Speaker.
The question now recurs on final passage of HB 133. The clerk will unlock the machine and the members will proceed to vote. Have all members voted? Have all members voted? The clerk will lock the machine and announce the vote.
74 yeas, 37 nays, Mr. Speaker.
Show the bill passes. Read the next bill.
By Representative Jacques and Representative Michael and others, House Bill 197, a bill to be entitled an act relating to employment eligibility.
Representative Jacques, you are recognized to explain the bill.
Thank you, Madam Speaker.
House Bill 197 strengthens Florida's workforce integrity laws by making sure that all private employers, regardless of size, uses the E-Verify system in order to confirm the employment eligibility of new hires. This removes the current exemption for employers with 25 or less employees, and that is the bill.
Are there questions of the sponsor? Representative Escamani for a question.
Thank you, Madam Speaker, and thank you, Rep. Jacques. Trying to see, there he is. Okay, I was like, where is he? Just quickly, obviously immigration is in the news all the time right now, and there's been a lot of concerns around this topic. So I'm curious, are there any due process protections that exist before a state can access private employment information with a private company?
You're recognized.
Thank you, Madam Speaker. So the current law already allows the Department of Commerce to verify if employers are abiding by our employment laws. So currently we have E-Verify for businesses with 25 or more employees. And not only the Department of Commerce, but the Attorney General's office, other prosecutors can ask for that information. And so it's part of just enforcing the law. And that would apply if we make it applicable to all employees as well.
Follow up, you're recognized.
Thank you, Madam Speaker. Are there any safeguards to prevent selective enforcement, i.e., how to make sure everyone's treated the same?
You're recognized.
Thank you, Madam Speaker. Any current laws on the books that would go towards that end will not be affected at all. So this doesn't add any new tactics. Everything stays intact. It just makes sure that all businesses will now have to comply, and they could be checked up upon by government.
Representative Escamani, you're recognized.
Thank you, Madam Speaker. One last question. If an employer believes that they are being targeted, is unfairly compared to their peers, is there a path to seek some sort of justice in that situation?
You're recognized.
Thank you, Madam Speaker. Again, the bill only applies to making it applicable to all employees. It doesn't affect anything that's in current law. Whatever remedies that might be available currently would be available.
Any further questions? Representative Joseph, you're recognized.
Thank you, Madam Speaker. So this bill has been up a couple of different times. And I know in the past there were no studies done on the impact on small businesses. Since the last time, have there been any studies done on the impact on small businesses of your bill?
Representative Jacques, you're recognized.
Thank you, Madam Speaker. Every time we bring this bill forward, there's a bill analysis that considers that very question, and the impact is very minimal. There might be a slight uptick in workload where you're inputting a name, social security, and address into a computer system that would have just been on the I-9 form. Otherwise, no significant impact. It's a free system. So the bill analysis is the studies that I'm aware of, and I'm not aware of any others.
Representative Joseph, you're recognized.
Thank you, Madam Speaker. And thank you for your response. Perhaps I should be more specific. I'm not talking about the kind of studies that we have in our bill analysis that give us vagaries about a minimal analysis. For example, on the national level, there have been studies that shows that E-Verify costs small businesses $81 million and will cost billions of dollars in the long term. So that's a national study that was part of Bloomberg's estimation, since they focus on financial analysis and impact on businesses. My question for you is, in the state of Florida, have we looked at the financial impact on small businesses in a similar vein?
That question's been asked and answered. Any further questions? Representative Daniels, you're recognized.
Thank you, Madam Speaker. I just want to ask one question. How does this bill relate to churches?
Representative Jacques, you're recognized.
Thank you, Madam Speaker. If they are an employer and they're bringing on a new hire, it would apply to them as well. So any private employer, whether that's in the nonprofit sector or the for-profit sector.
Any further questions? Seeing no further questions, are there amendments?
None on the desk, Madam Speaker.
Show the bill rolled over for third reading. Representative Jocks, you are recognized for a motion.
Thank you, Madam Speaker. I move that the rules be waived and that House Bill 197 be read a third time by title and placed on final passage.
Representative Jocks moves that the rules be waived and HB 197 be read a third time by title and placed on final passage. All in favor say yay. All opposed no. Show the motion adopted. Read the bill a third time by title.
By Representative Jacques and Representative Michael and others, House Bill 197, a bill to be entitled an act relating to employment eligibility.
Are there any amendments?
None on the desk, Madam Speaker.
Members, we are going into structured debate on HB 197. Debate will be limited to 10 minutes per side in 10-minute increments. Total debate time not to exceed 20 minutes. Representative Gottlieb, you are recognized to begin in debate, and the clerk will start the clock. Representative Gant, you are recognized.
Thank you, Madam Speaker. I yield to Representative Henson.
Representative Henson, you're recognized.
Thank you, Madam Speaker. Representative, you're about to hear the same debate I made in committee when I had so many questions. According to the Florida Policy Institute, E-Verify burdens employers, especially small business owners. Employers must read a 145-page user program. There are also significant time and cost burdens involved. This is what's going to happen with churches, too. Since Arizona implemented E-Verify, one small business owner tried to hire a part-time worker, but a technical glitch that took days to fix made it needlessly difficult. Bloomberg estimates that in 1 year alone, E-Verify cost small businesses $81 million, as the representative pointed out. Florida's agricultural industry would face significant challenges, in particular, as farmers must fill jobs quickly in geographically isolated areas, making them reliant on a high density of foreign-born migrant workers. The industry is already struggling in the wake of the state and nation's anti-immigrant policies. After Georgia passed its E-Verify law in 2011, one farmer alone witnessed 300 field workers flee, which will likely force him to abandon about 25% of his 125 acres at a projected loss of $250,000 this season. Furthermore, this legislation makes no exception for most household employees. As such, everyday Floridians would be forced to use E-Verify before hiring child care workers or caregivers to their senior loved ones. This has high implications for Florida's growing senior population, which currently comprises over 1/4 of the state's residents. E-Verify is ineffective at reducing undocumented workers in the labor force. Conservative think tank Cato Institute found that among the states that have mandated E-Verify, employers and employees alike are widely ignoring the mandate, even with much more aggressive enforcement than this bill outlines. Only half of employers are complying. Moreover, this due to errors in the government databases that support E-Verify. The system may incorrectly reject a U.S. citizen or documented immigrant. According to the government's own statistics, almost 15,000 Florida workers will receive an error, with the latest independent evaluation estimating this at over 25,000. This means companies will hire workers, put them through E-Verify, and then be forced to fire them within 8 days or risk federal liability. In fact, documented immigrants and green card holders are over 27 times and 4 times more likely, respectively, to be subjected to E-Verify. I urge you to reject this bill. Thank you, Madam Speaker.
Representative Gant, you're recognized.
Thank you, Madam Speaker. I yield to Representative Woodson.
Representative Woodson, you're recognized.
Thank you, Madam Speaker. Members, I was hoping that I would not see this bill again in this chamber, because I know this bill passed in the House, but it did not make it on the Senate side. And there was a valid reason for that. I know we're talking about illegal immigration. Behind illegal immigration lies people, human beings, real people that we're talking about. And we are talking about an e-verify system that we know that is not reliable. It is not a reliable system based on what we know for fact. The system has issues. On top of that, we're talking about small businesses as well that have to use this type of system. Our small businesses are going through a lot right now when it comes to finding people to support, to work for those small businesses. I had several of them reaching out to me saying that they cannot find people to work because, as we know, as of February 3rd, 2026, TPS, temporary protected status, will expire. And don't think about TPS just because I'm standing here talking about TPS, that I'm from Haiti, that I'm just referring to Haiti. TPS is not just for Haiti. TPS has people from El Salvador, from Venezuela, Nicaragua, Honduras, everyone. So when we're talking about using a system to impact immigrants, let's give it some more thoughts to see how are we impacting our small businesses that make up such a large amount of our GDP. Think about it for a minute. It's all about immigrants, immigrants, immigrants. But those immigrants did not leave the country because they wanted to come here just to come to a country. They come here just like a lot of us who are in this chamber came here because they're fleeing persecution or they want to have a better quality of life just like y'all. So when we're saying just we want those small businesses under 25 to use this e-verify system, we're creating more problem than we can ever imagine. So think about it first before we engage in this piece of legislation. And Representative Michaels, I would say I am so sorry about what happened to you. And I know I can never imagine how you're feeling, losing your son like that. I'm really, really sorry. But I'm just asking for us to think about what we are doing, what we are saying, because we cannot make everyone else pay for something one person did. So I'm asking you members to think about it first before you vote on this legislation. Thank you.
Representative Gant, you're recognized.
Thank you, Madam Speaker. I yield to Representative Joseph.
Representative Joseph, you're recognized.
Thank you, Madam Speaker. If the goal is to ensure that people who are legally authorized to work, then we have a system that takes care of that already. The I-9 process is reliable, it's universally required, and it's always available. Unlike the I-9 process that I just described, which is never down, the E-Verify system is consistently down with technical issues, persistent periods of unavailability. This puts a strain on our small businesses. And I know if you haven't had a small business, you may not understand the impact of that strain, but it is significant. That $81 million in 1 year is significant. For you, that may be nominal, but I assure you, for the small businesses in this state, it is not a nominal cost. And it puts them at risk of being charged with federal fines of $2,000 or more. That too is not significant. That adds to additional compliance costs. There's nothing in the current law that prevents employers from voluntarily using the E-Verify system. Why do we need to come down heavy-handed with this government mandate that forces unnecessary bureaucratic burdens on our well-meaning small businesses, businesses that are abiding by the law. Right now, when we think about the impact of these on specific communities, it's going to disproportionately impact not just immigrants, but African Americans or anyone who has an unusual name, which is where most of the errors come in. At a time where these communities are under attack, we don't need to add any more fuel to that fire. Stop doing the most. Just leave hardworking immigrants alone. Let law-abiding businesses do what they need to do, and that's focus on their businesses. The I-9 system works just fine. It keeps compliance costs low. It limits exposure to federal fines. And most of all, it's reliable. And if our goal is actually just to make sure that people who are legally working supposed to work, then it does that. We don't need this fake fix forcing private employers to use a broken and unreliable federal database system in the form of big government mandate is bad for business and bad for Florida. Please vote down.
Debate time having expired on the con side, Representative Maggard, you are recognized.
Thank you, Madam Speaker. I yield the floor to Representative Jocks.
Representative Jocks, you are recognized.
Thank you, Madam Speaker. I just want to address for my debate a few of the points that were made on the other side. There's a lot of conversation about the burden on small businesses, and I assure you that this is not burdensome to small businesses. I assure you of that because this is nothing new, and there are many small businesses right now in real time using E-Verify regardless of the size of their employees. I say that because since 2021, the state of Florida has passed E-Verify. It applies to all state workers and any businesses that contracts with the state or a local government. So that's for anybody who puts in a bid for a project and any nonprofit that gets an appropriation from this body year after year. Dollars go out to these organizations, and not once have I heard a nonprofit who is getting state grants telling me this E-Verify thing is too burdensome. As a matter of fact, last committee meeting, and during the stop, I was addressing this particular issue, and a small nonprofit owner back in Pinellas County told me, Bernie, you're right, it's not that hard. We have to do it every year because we contract with DJJ. It's not that hard. And it's not that hard because you're literally putting in 3 pieces of information: the person's name, their address, and their social security, things that are on the I-9 form, and you're just putting it in the portal where you get an answer from the E-Verify system, which is not a new system. It's been around for quite some time, Madam Speaker. The issue of reliability was also brought up. Over 98% are confirmed within seconds, Madam Speaker, within seconds. And if they're not confirmed, the system tells you there's a tentative non-confirmation. We might need a little bit more documentation. Get with the employee and see whether or not they can clear this up. They even give them the benefit of the doubt. And this is something that does not have to happen until within 3 days of the initial hiring. So it's not something you have to drop everything and do immediately. Over 98% confirmed within seconds. And then I heard the I-9 is somehow reliable. The I-9 is just a form that you can put in a file cabinet that just collects dust, that doesn't confirm anything. It's the E-Verify system that confirms the information that is on the I-9 that for whatever reason they don't want you to know the answer of. For some reason, they don't want you to know the answer of what's on that I-9. I would imagine it's because a lot of people filling out that I-9, Madam Speaker, are not legally authorized to work in our country and in our state. And if this bill passes, it will expose a lot of lawbreakers that are harming Floridians, harming law-abiding people who want to get into the workforce, harming law-abiding businesses that I've talked to that tell me, Bernie, we're doing everything right, but my competitor down the street, I know he's hiring people who are not here legally, and I'm losing out on bids because I'm paying Americans at a higher rate. I'm paying legal citizens at a higher rate because I'm complying with the law. And this system, if it's applied to all, the competition will be fair to all. I also heard one of the debaters say, leave hardworking immigrants alone. Leave hardworking legal immigrants alone. Because if you are in this country legally, you should not be left alone. You have no right being here, and you are breaking the law. Simple. And this system will make sure that we know who these people are and the businesses that prey upon them. That same business owner told me that his competitor down the street is able to do all sorts of abuses to these people, and these people don't have recourse. They're not going to call the authorities. Why would they? They're in the country legally. So you have a system of employers out there who are literally preying and victimizing people, knowing that the very people that they're doing that to will never say a word because they know they don't have status. So they're undercutting the legal worker, they're undercutting the American, all while getting all sorts of abuses that they're getting away with. Madam Speaker, it's time for us to finally get this done. This House has done it over and over and over again. And we call on our partners in this building to get it done as well, to finally strengthen Florida's workforce integrity laws, to make sure that no longer do we allow workers to hide in the shadows when there are laws in the books that simply don't allow it. And for that, I urge my colleagues to vote up on this good bill.
Representative Maggard, you're recognized.
Thank you, Madam Speaker. We waive the rest of our time back in totality.
Having waived back the rest of the time, Representative Michael, you're recognized to close. You're recognized. From Esposito's desk. There you go.
Thank you, Madam Speaker, and thank you, Representative Jock, for bringing this bill on the floor, for carrying it all the way through. I want to thank my husband, who's up in the galley, for always being my steady rock, because a lot of people forget the fathers that are impacted, the fathers that have had to hold us together. You all know my story. Everybody in here has heard it. Our middle child killed Brandon Randolph Michael by a twice deported illegal that continuously defied our laws. That is the reason why I continue to stand here. And it's not just about my son. As I'm standing here, I'm looking at the bands of other people's children who were killed by illegals that I know personally. And every one of them that I have here, I deliberately picked out. I had more that I could carry. I deliberately picked out the ones who were killed by illegals who were working somewhere. In the case of like our son, the illegals were working, they were earning money under the table and sending it back to the country that they came from. If we had simply done something as simple, if we had E-Verify to confirm that they had a right to work here, they were here legally, it could have saved Brandon's life. Brandon was going on his lunch break to cash his check, as you all have heard so many times. The illegal was going to buy paint, and it cost our family. Am I angry? Absolutely. And for those on the other side of the aisle, if it was your child, you'd be just as angry. You'd be fighting too. I would hope that you would. When the question was asked about the churches, one thing that we have to keep in mind is that I would want to make sure I know who is volunteering in my church, who's working in my church, who's working in my business, because I really took a look at what we have since Biden has been in office, and this goes back, in my case, prior to Biden, so it's been a problem for a long time. Who's actually come across the border? What has actually come across the border? E-Verify can prevent you from hiring someone like an illegal from El Salvador convicted of sexual assault of a child, a criminal illegal and registered sex offender from Somalia convicted of 17 crimes, including 4 counts of larceny, vehicle theft, receiving stolen property, forgery, domestic violence, threatening terrorist state offenses, driving under the influence of liquor, intimidation, escape from custody, property damage, There's an illegal from Guatemala. He was arrested for attempted sexual assault. They're from all over. An illegal from Laos. Attempted sexual assault in conduct on a victim under 16 years of age. Domestic violence, receiving stolen property, contempt of court, driving under the influence of liquor. There's an illegal from Somalia. Possession. He was arrested for possession of opium, derivatives, driving under the influence, possession of hallucinogens, fraud, attempt to commit burglary, larceny, and 20 other crimes. We have another one, and I'll never say their name because I'm not going to give them that kind of credit. They don't deserve it. They've broken the law. They've harmed people. We have another one from Mexico, altering identification on a weapon, domestic violence. 2 counts of driving under the influence of liquor and larceny. Another one from Mexico, convicted of assault, resisting an officer, illegal reentry, driving under the influence of liquor. We have another illegal, convicted of assault with a dangerous weapon, drug possession, and larceny. We have one from El Salvador, domestic violence, shoplifting, disorderly conduct. And lastly, I will say we have another one from Mexico. He was convicted of identity theft, selling cocaine, selling amphetamines, an illegal from Somalia, convicted of driving, drunk driving, and possessing a fake name. So what I will say is, when they talk about the cost, does it cost us as Americans? Yes. We're watching the great switcheroo happening. We can look around and we can see it. The jobs that should be going to Americans are going to people. They have to put whatever they're trying to say into a phone to translate, to communicate with us. There's something wrong with that. And it is impacting not only immigrant communities. The black community was brought up. I can vouch for that. My son is an independent business owner. It's very difficult for him to find jobs because very often he is told he can hire them for cheaper wages. And it is a form of slavery. I've been here several times before you all. I've poured out my heart, asking that as legislators, we remember the oath of office that we took, not to those that are not in this, that are in this country legally, but to those who are American citizens. We promised them that we would uphold the oath that we're taking. And you're absolutely right, I'm saying that, because we should uphold our oath. We cannot do that without ensuring our families are able to provide for themselves. They need good jobs. We need a sound economy and the opportunities that as a nation we're responsible to maintain for the future generations. Our families shouldn't have to wait behind or an increasingly growing trend that we're seeing. They're being turned down by employers for cheap labor. We have to continue to remove the magnets that draw illegal immigration to our great nation. And I do hope this is the very last time we will find it necessary to have to bring E-Verify back before this chamber. I hope we get it right, and I hope it's passed in the other chamber. I hope that is picked up and passed. I ask that you remember my son. Remember the other victims. Remember the young people. Remember your nieces, your nephews, your grandchildren, your wives, your husbands. E-Verify is worth it to get it right. Every life matters. If it takes a few seconds and it saves lives, then it's worth it. And with that, I close.
The question now occurs on final passage of HB 197. The clerk will unlock the machine and the members will proceed to vote. Have all members voted? Have all members voted? The clerk will lock the machine and announce the vote.
80 yeas, 30 nays, Madam Speaker.
Show the bill passes. Read the next bill.
None on the desk, Madam Speaker.
Read the next bill.
By Health and Human Services Committee and Representative Overdorf and others, CS House Bill 121, a bill to be entitled an act relating to nursing education programs.
Representative Overdorf, you are recognized to explain the bill.
Thank you, Madam Speaker. Members, Florida currently has a nursing shortage which is predicted to grow to 56,380 nurses by 2037. The legislature has taken numerous steps to combat the predicted shortfall, and this has resulted in 944 new nursing education programs in our state over the last 20 years. This past year, Florida had the most students in the country take the nursing certification exam known as the NCLEX. Unfortunately, Florida first-time NCLEX test takers have consistently scored well below the national average for the past 2 decades, currently ranking dead last among the 50 states. Members, this is not acceptable. This is not acceptable for Florida. This is not acceptable for this chamber. Not only do we fail to address our nursing shortage, but it leaves students who are unable to pass the NCLEX with high student loan debts and no ability to earn an income. The goal of this legislation is to create accountability for underperforming programs so that they can someday be counted amongst the highest performing programs in our state and our nation. Members, that is the bill.
Are there questions of the sponsor? Seeing no questions of the sponsor, are there, one question. Sorry, Representative Bartleman.
Thank you, Madam Chair, or Madam Speaker. Rep. Overdorf, I just wanted to ask you a question about, because not everyone got to see this bill in committee. Can you go over the pass rates of our tests in the state of Florida and how that compares everywhere else? Because it's very compelling.
Representative Overdorf, you're recognized.
Thank you very much, thank you for the question. Yes, we've actually looked at the passage rates all across the entire country, and we look back at 2020, we were 53rd out of 55 overall regions, and going on from there, 52nd out of 55, 52nd out of 55, 52nd out of 55, 52nd out of 55, and 53 out of now 54. So we are not doing well. I will say that I'm incredibly grateful for the islands of Samoa because they are behind us, and they have a worse passage rate, but other than that, Florida is the worst. Thank you for the question.
Any further questions of the sponsor? Seeing no further questions, are there amendments?
None on the desk, Madam Speaker.
Show the bill rolled over for third reading. Representative Overdorf, you are recognized for a motion.
Thank you, Madam Speaker. I move the rules be waived and CS for HB 121 be read a third time by title and placed on final passage.
Representative Overdorf moves that the rules be waived and CS for HB 121 be read a third time by title and placed on final passage. All in favor say yay. All opposed no. Show the motion adopted. Read the bill a third time by title.
By Health and Human Services Committee and Representative Overdorf and others, CS House Bill 121, a bill to be entitled an act relating to nursing education programs.
Are there any amendments?
None on the desk, Madam Speaker.
Is there any debate? Seeing no debate, Representative Overdorf, you are recognized to close.
Thank you, Madam Speaker, and I want to say thank you, Madam Speaker, for all your efforts associated with this bill. Thank you also to Speaker Perez and also to Senator Harrell. I look forward to the signage of this bill and having it move forward. Members, I ask for your support. Thank you.
The question now occurs on final passage of CS for HB 121. The clerk will unlock the machine and members will proceed to vote. Have all members voted? Have all members voted? The clerk will lock the machine and announce the vote.
107 yeas, 1 nay, Madam Speaker.
Show the bill passes. Read the next bill.
By Healthcare Facilities and Systems Subcommittee and Representative Oliver, CS House Bill 355, a bill to be entitled an act relating to healthcare patient protection.
Representative Oliver, you are recognized to explain the bill.
Thank you, Madam Speaker. House Bill 355 strengthens the ability of Florida's emergency departments to treat and stabilize children in life-threatening emergencies. You may remember this bill from last year as it did pass off the floor of the House. However, it stalled out in the Rules Committee. We're really hoping to get it across the finish line this year because Florida's children deserve better. Every day, children in Florida experience medical emergencies, from respiratory failure to severe infections to trauma. And although we have excellent children's hospitals and excellent emergency departments, the vast majority of Florida's children receive emergency cares in general hospitals. But only a small percentage of EDs nationwide meet evidence-based pediatric readiness standards. Research shows that children are 4 times more likely to die in an emergency department that is not prepared to treat them. We can and must do better. House Bill 355 establishes basic common sense safety requirements for any hospital with an emergency department to develop and implement policies and procedures relating to pediatric patient care, conduct training on those policies and procedures, designate a pediatric emergency care coordinator, conduct the National Pediatric Readiness Assessment. It requires ACA to publish the hospital scores online. And finally, and I think most importantly, this bill requires ACA to adopt rules for minimum baseline standards for pediatric care in hospital emergency departments. And that is the bill, Madam Speaker.
Are there questions of the sponsor? Seeing no questions of the sponsor, are there amendments?
None on the desk, Madam Speaker.
Show the bill rolled over for third reading. Representative Oliver, you are recognized for a motion.
Madam Speaker, I move that the rules be waived and CS for HB 355 be read a third time by title and placed on final passage.
Representative Oliver moves that the rules be waived and CS for HB 355 be read a third time by title and placed on final passage. All those in favor say yay. All those opposed, no. Show the motion adopted. Read the bill a third time by title.
By Healthcare Facilities and Systems Subcommittee and Representative Oliver, CS House Bill 355, a bill to be entitled an act relating to healthcare patient protection.
Are there any amendments?
None on the desk, Madam Speaker.
Is there any debate? Seeing no debate, Representative Oliver, you are recognized to close.
Thank you, Madam Speaker. And thank you, members. This bill ensures that when a child in Florida experiences a medical emergency, every emergency department, large or small, rural or urban, has the basic capacity to give that child a fighting chance. I ask for your favorable support.
The question now occurs on final passage of CS for HB 355. The clerk will unlock the machine and the members will proceed to vote. Have all members voted? Have all members voted? The clerk will lock the machine and announce the vote.
109 yeas, 0 nays, Madam Speaker.
Show the bill passes. Read the next bill.
None on the desk, Madam Speaker.
All right, members, we have a few announcements before we close out here. Representative Gantz.
Thank you, Mr. Speaker. I don't know where Rep. Henson went, but today is the 118th anniversary of the founding of my sorority, or our sorority, Alpha Kappa Alpha Sorority Incorporated, which is the first Black Greek letter organization for women, founded in 1908 on the campus of Howard University. So happy Founders Day to all of my sorority sisters. And just of note, all of the women, the Black women in the Senate, are also members of Alpha Kappa Alpha. Thank you, Mr. Speaker.
All right, Representative Gantz. Thank you. Happy Founders Day. Representative Anderson.
Thank you, Mr. Speaker. Members, today in the House Journal is a resolution recognizing the 175th anniversary of the one and only Florida State University. Thought you'd like that, Mr. Speaker.
Thank you, Adam.
FSU here in Tallahassee was founded in 1851 and is the oldest continuous site for higher education in Florida. Today, FSU is a leading national research institution with 17 colleges, over 46,000 students, 16,000 employees, national study centers across the world, and an estimated annual economic impact of over $15 billion. Under the leadership of President McCullough, FSU ranks among the top of all public universities nationwide, with multiple academic programs ranking in the top 10.
and a first-year student retention rate of 97%. The 2025 freshman class is the brightest in the university's history, with enrolled students from all 67 counties in Florida and all 50 states across the country. The university has invested close to $500 million in research last year and submitted over $1.2 billion in competitive grant proposals to extend groundbreaking initiatives in areas like quantum science, AI, aerospace, and healthcare. FSU is on the forefront of Florida's national leadership in genomic and precision medicine, and it's home to the first of its kind Florida Institute of Pediatric Rare Diseases, and it leads the cutting-edge Sunshine Genetics newborn screening pilot program that's offering Florida's babies the opportunity for whole genome sequencing at birth, extending the list of conditions that we screen for from 60 to nearly 600 conditions. Members, get out your garnet and gold next week and join us on Wednesday, January 21st for FSU Day, and join me and my fellow alumni in recognizing some esteemed alumni in the West Gallery and members of the legislative team, former member Clay Ingram and Lena Roja. Welcome to the Florida House. And go Knowles.
On behalf of Representative Kinkard-Johnson, Representative Grow, and myself, go Knowles. Representative Garrison, you are recognized for a motion.
Thank you, Mr. Speaker. And members, prior to the motion, just to be noted for those of you on the Rules Committee, there will not be a meeting after session today. Thank you, Mr. Speaker. I move that the House, after receiving reports, adjourn for the purpose of holding committee and subcommittee meetings and conducting other House business, to reconvene upon the call of the chair.
All in favor say yea. Opposed, no. Show the motion approved. The House is adjourned.